Any original site mentioning?
My lord,
Yes.
this is a matter of division bench.
No, division bench, when I take up division bench matters, please mention them.
My lord, 13th October.
Singly, I
is
cannot
the-
give you any leave.
Sir, my lord, 13th October is the last date for fixing a date for demolishing of the unauthorized construction. So
I'm
leave
extremely
is
sorry,
made-
sir, but I cannot grant you leave sitting singly in a division bench matter. It's not possible. Otherwise, no, same applies to you. When I sit in division bench, yes. এটা যেটা বলেছে এটাই এর সিস্টেমের যে উত্তর সেটাই দিয়ে দেবে বন্ধ কর সিস্টেমের প্রবলেম হচ্ছে রিপিটিশন হচ্ছে peculiar. We all blame the system for a reason. System. So it will go on, please. এটা স্টপ করুন কিছু কারেন্ট মামলা শুনি চলুন দেখুন
Listed matter item number 1 to item number 4.
yes
Lord, I have a GA over here. Your Lordship will remember, Lord, there's a section 34 filed by my learned friend.
yes
They had attacked, Lord, applied for setting aside an award. Their case had been there's no notice under section 21, there's no award, everything is made up. Now, Lord, we filed an application to bring on record the section 21 notice issued by them
yes Mr. Bosa,
and other documents.
My lord, I have
He has
not
to-
been
no,
served
just
with
one
it.
sentence. Just one sentence. Just one, Lord. He may either file an affidavit if he wants to argue it. I'm Lord.
section 21 can we permit them to rely on the section 21 if they give an advance copy to
We have
My lord,
petition has been.
my lord, they appears they have filed an, you may remember, they wanted to push a supplementary affidavit to Learned Junior, which was opposed, and you did not allow. Now
we
it
filed
appears from what I know, they have filed another, basically
Not another, first.
a first GA in a particular AP saying whatever the GA. My lord, no copy has been served to me, so I don't know what I am to say.
Taken out the notice of motion.
Let's
So,
serve.
they say they have served probably but
Otherwise, I can
anyway.
take out the notice of motion.
well, my advocate on record says
show them the service
Affidavit of service being filed.
Lord, it's been
Affidavit of
filed.
service.
You've taken out the notice of motion. Without it, it can't
to
be
the
filed.
client or
Mr. Mitra, you are for which side?
well, he's my leader. He said if there is fighting, you
Then
fight.
when he'll come.
Because I cannot fight with him. I said this
Sir,
is
let us have a fighting because we want the opportunity to hear. Mr. Mitra.
because you won't fight.
Well,
Because he's junior, chamber junior.
Well,
I mean, he rang me up, said, you please come.
But this is innocuous, I suppose. With that section 21 notice they want to bring on record.
Because there's section 34 goes,
it is
that's
part
the
of
only
the-
argument made.
records.
There's a section 34 doesn't go. The award, your lordship asked on the previous day, have you bought the original award? Said no. I want to show that a particular notice was served on a particular person. I can give you the answer to that immediately.
Or this section 21 might change the complexion entirely because this was that matter.
Correct.
That,
Section 21 does not change the matter
Yes, he
because
said they have
someone
not
has
appointed
stamped.
any
My
arbitrator.
lord, it was a company which was taken over.
even if it was a section 21, you say that
Yes.
the award is a nullity.
My lord,
sort of.
that's a
That's not the argument
absolute-
made.
So can we
Argument
have
is
that
not.
21 and proceed with the matter?
No, I
We'll record your dispute maybe.
No, I need to, I mean, if there's an application, I need to file because I will tell you, it's a complete fraud. The people who have stamped it, because our says there is no such section 21. You see, that's the point.
That is important. Then
I know.
Then instead of let us avoid the dispute regarding service and they'll give a fresh copy and file whatever.
Yes, I have to, because I have to dispute it, right? I mean,
Only thing is this.
Yes.
I'm not standing in the way of anybody relying upon documents because my lord, your lordship will have to look into it, the totality of facts. The only thing is after 3 days of hearing, my learned
That's
friend comes
true,
out,
that's true.
comes
No,
out
no.
with that.
But we have explained
Of hearing.
the gentleman looking after it was suffering from cancer. Not all his documents, and he underwent surgery. All those documents.
Mr.
are next.
Bachawat, let us just give another copy to them. Just
I-
hand over a copy.
Yes.
Let them have a response to this, and we'll
Very well.
hear
We
on this
shall do
application. And
that. Well, only thing is this, my lord, apropos what has been submitted by a learned friend, the gentleman who is supposed to be looking after this He has not signed
Are these
any
there?
other document. This is the only document which
And
my lord
his ailment is being taken advantage
yes,
of.
yes, taken advantage
You
of.
can put that in your response, a
is
very short
yes,
response, and
yes,
we'll deal with that. And
My lord, we
Yes,
cannot
either take it
prevent
or-
anyone from filing an application.
understood, understood.
But I've handed over copies of both. Not
The GA is appearing today in the list. JCOM 1.
He is appearing.
GA,
G1.
GA appeared.
JCOM 1 is appearing in the list, in fact.
List appear coach.
List appear.
list here.
Yes, it is there.
appear.
Yes, it is appearing.
It's appear.
JCOM 1.
I-
After order
Log
record,
list দেখেন না, that's
there
the problem.
appears to be some
Yeah,
dispute as to
একবার
whether
তাকে
a
list বেরিয়ে
copy of GA COM 1 of 2025 has been served on the petitioner in the application under section 34 of the Arbitration and Conciliation Act 1996, full stop. Whereas learned senior counsel appearing for the respondent, comma, on instruction, sorry, petitioner, comma, on instruction, comma, disputes that such service has been effected, comma, his counterpart appearing for the respondent in the main matter submits, comma, by placing reliance on the affidavit of service which has already been filed, comma, that service has actually been effected. Full stop. Be that as it may, comma, to avoid unnecessary controversy at the peripheral stage, comma, the petitioner in the main matter is requested to serve another copy of the application.
I have served.
Just now.
Acha. Is requested to serve another copy of the application
Not
on the
petitioner.
petitioner.
The respondent is directed to serve.
Respondent is requested to serve
Yes.
another copy of the application on the petitioner, which is done here and now. Full stop. Response, comma, if any thereto, comma, shall be filed by the petitioner within a week from date with advance copy to the learned advocate on record for the respondent. Full stop. The application shall be taken up along with the main matter for hearing on October 31, 2025. I'm not directing any further reply at this stage.
I don't think necessary. We shall look into
The
it.
Lordship will say, not if he's giving me advance copy, I'll file a reply, not if necessary. If necessary, say that because
My lord, to avoid complication, it's just one document they want to rely on. I'll say whether it's a
So regarding service of that notice, you may have something to say.
yes, that's
We
the
have.
only
That's
thing.
why I requested you to file.
Now he wants to file another reply. In another reply, more documents.
Right
which
now,
come.
we are not directing. If you want to file a reply, we are not saying anything on that.
Very
Give them an advance copy and we'll consider that.
So, my lord, your lordship is.
I'm taking it up on next Friday, October 31st, along with the application. So use your response in the meantime. Please serve them a copy of the response.
পারবে তো?
Please serve them. Yes, he will do. Serve them a copy of
We have taken instructions already.
that's why
Ah.
it will be a very short response. Give an advance copy to them and to your counsel also. Yes,
embarrassing, but not could it be on the not Friday after?
Friday after that.
I have some personal problem.
7th, my lord, I will not be here.
Friday 7th, I may have to leave the court early for some official purpose. So
He will, my lord. I
then it will have to go to
পরে হবে।
14th of November. So should I put it on 14th?
Correct.
Then I'll put in that permission, that liberty to file a response. reply.
if any.
Yeah. My lord, they will annex more documents. It goes-
আচ্ছা, ছেড়ে দাও,
Hey,
এটা
আমি
নিয়ে
কি দেবো তো? Not your
Sir,
Lordship called him my counterpart. I can't ever be his
My lord,
counterpart.
My lord, let it have
Focus
it.
is everything.
We have waited and got our turn. So that's why this is one aspect. And the other thing, my lord, I think.
No, this is now the number one item in the part at least. So
No,
no
but still,
the matter for which you waited, the judgment will be delivered next Friday. So no difficulty.
no, I did not wait. He was waiting.
Which one?
Oh, no, that is Mr. Jishnu.
So Jishnu and Messrs. Jishnu.
Message Jishnu.
Yes.
Yes, I know.
So that date will be not October 31st, it will be November 14th, 2025.
No, so please extend my time also and give them, time to fight. Since he's being fixed on that day.
No, we are giving you,
But may I suggest this one? This is too much of controversy. 10 days, 4 days, and my lord, the matter will appear. on
আচ্ছা যেটা বললাম সেটাই থাকবে নভেম্বর 14th এর নেক্সট রিটার্নেবল ডেট। আগে যে ডেটটা বলেছি একটা উইদিন 1 উইক ফ্রম ডেট, রেসপন্সটা উইদিন 1 উইক ফ্রম ডেট, 1 উইক উইদিন 1 উইক ফ্রম ডেট না করে উইদিন নভেম্বর
না,
2 weeks কেন নেই?
4, November 4, 2025. Proof of reply, if any, shall be filed on the next returnable date.
with an advance copy to us.
Yes, yes, sir.
Always.
All with advance copy.
Yes.
Not to Tilak. ও বলবে আবার fine.
And happy Diwali to you.
Same to you.
But after the fireworks, after the fireworks, he
There is
said,
no firework. He rang me up and said, "You please said I cannot tackle him. He's my junior." I said, "If he," I told him, "You are always soft on him."
Not that I can
"Hello, this is
tackle
like
him, but I said
Donald
that
Trump."
I'm
I've not seen anybody on whom Mr. Mitra is harsh, be it his junior or otherwise,
And
or the
he's-
court.
He's
the court even.
extra soft on him. I said, "Leave it to me. I mean, physical. I get physical with
My
him."
lord, Mr. Bose is now talking like Mr. Trump. In that telephone conversation, this is what happened, and that is immediately denied.
This is a real insult, sir.
My lord, he went to that country. He was there now for 2
Yes, he
weeks.
was there.
Infection.
We have to see how he came back. I mean, he was turned out or own volition or what? Next.
Item number 5 with item number 6.
Please, Your Lordship, Lord, I'm
You won't be
appealing
let
for
off. You have to do the matter.
We have already made our submissions, my Lord. Mr.
Oh,
Pradeep
then
Indra, my Lord, he was appearing virtually.
yes,
for
yes,
the for the petitioner, my Lord, in section.
Mr. Chinda is there actually. Yes. Yes, great. Yes. What is it? Please continue, Mr. Chinda.
So we should start, Malaj, with the matter.
Absolutely. Right
Yes.
off.
Yes. So, Malaj, just before we set into the matter, Malaj,
Yes.
there are two parts in which my submission would be based. Malaj are aware of the, Malaj have a bird's eye view of the matter as to what exactly my aspects are going to be. But broadly, my submissions are going to be divided into two parts. One is a part, three parts actually. First is a preliminary part where I say, Malaj, that the award is invalid and award is marred by fraud. The second part is how it is in violation of one of the sections of Arbitration and Conciliation Act. I would then be focusing on as to how, Malaj, that given everything against me, the award could not have been passed. That's going to be the second leg of the argument. And finally, what is the positive evidence that was put on behalf of the claimant here, on behalf of the petitioner here and the respondent before the Honorable Tribunal, as to what positive evidence has been overlooked.
Mr. Chinda, would you give me half a minute's time to adjust the camera, please?
Sure, Malaj, sure.
ক্যামেরা কি আছে বাবু? এই ক্যামেরাটা একটু সামনে করে দেওয়া যাবে কোনোভাবে? এই তুমি এদিকে ঘুরে এসে দেখো, এদিকে ঘুরে এসো, ওপরে চলে এসো, ঘুরে আমার জায়গাটা দিয়ে ওপরে চলে এসো, তা নাহলে পারবে না। Just give me 5 minutes time. It's very difficult because
No
I'll have a stiff neck.
No,
Literally.
no, I'm so sorry. Malaj, I would have been there had it not been the Diwali vacations. I would have been there, but because of the Diwali vacations,
No. You should not be sorry.
I would have loved to be there for the
এরকম
honor.
জায়গায় জাস্ট মানে উকিলদের একদম মুখ ব্লক না করে উকিল বাবুদের এরকম একটা জায়গায় ওটা কি আচ্ছা তো ওটা আসবে না ও থ্যাংক ইউ এটা ঠিক আছে দিস ইজ সাফিসিয়েন্ট ঠিক আছে কতটা আসবে এই ব্যাস থ্যাংক ইউ ঠিক আছে
Yes.
Fine.
So, Malaj, my first leg of the argument, which my lords are very, very familiar with, and my lords also have taken notes in the last date of hearing, is going to be that how the majority award of the tribunal is marred by fraud, and I am covered by section 34(2) of the Arbitration and Conciliation Act specifically. And as such, the explanation, I would, of course, be saying in my legal submission that I'm covered by a classic section 17 fraud under the Contract Act, my lords. But even otherwise, if my lords are not with me on the point of section 17, even otherwise, my argument is going to be that anything which has to do, which is a fruit of fraud, or anything which is remotely connected with fraud, that would also have to go, because fraud unravels everything. That's going to be my alternate submission of the fraud if the Honorable Court is not with me on the point of section 17. Now, my lords, having put that point, I would just draw my lord's attention first to the award. There are two awards, my lords. There is a majority award of 22nd of July 2020, which I am impugning to be an award which has been obtained by fraud, inasmuch as the presiding arbitrator was not in a mental and a physical capacity to have gone through, sifted through, had the time to reason with, had the time to reason with the other co-arbitrator, and given an 120-page award. So, Malaj, not to mention, I'm just mentioning the preliminary facts, not to mention the arbitral tribunal proceedings went on for 10 years.
Mr. Shindra, I'm being very candid because this is a section 34 and this is a you are in reply
Yes,
because
madam.
you made your argument in substance,
Yes.
and I'll be inviting written notes also so that I don't miss out anything.
Okay.
Let us be very need not. I mean, you just make your just remind your
Point.
points in a nutshell and just deal with whatever they argued so that we can conclude the hearing.
Sure, Manoj. They did not argue anything. We have argued, they are yet to argue.
Oh, your argument is still going. So
Yes,
if you
They
just
are
conclude.
yet to argue and then there is a rejoinder.
Remember now. So, Mr. Chinda, just make it brief so that because you have argued at length. So
Sure.
I remember the broad contours of it. You just give
There are
body
some
to your.
portions,
Yeah.
portions which my lords may not have gone into in detail. First, one or two arguments, I'm pretty clear, my lords are clear on that.
Right.
I will go into a little bit of details in the points on the merits of the matter, so to
So
say.
let us do that. I mean, as
No
early as
difficulty, no
Right.
difficulty.
Right.
So my first argument is that it is fraudulent for the reason that the presiding arbitrator did not have the mental and the physical capacity
Right.
to have actually gone into and written the award. I'm just putting the pointers right now, Manoj. Number
Yes.
one.
Yes.
The award has been prepared on dotted lines. He has signed on dotted lines in as much as the award is written in the first person. So the impression that has been given both to the Honorable Court and to me is as if the presiding arbitrator is writing the award.
Yes.
That could not have been so because he was discharged on a day before the pronouncement of the award. The award is 22nd of July, Malaj. He was discharged on 20th of July, 2020.
Yes.
4 dates are relevant, which my lords are already aware. And 2 periods and 4 dates are relevant.
Right.
The last hearing before the tribunal was 18th of January, 2020. Malaj may note that it's at page 27 of the application file in the award itself that is written. I'm not taking my lords to that. I'm just mentioning so that it's
Need
easier,
not.
for that it's easier for the court to refer later.
Absolutely.
That was the last hearing, Malaj. We submitted the notes of argument on 28th of February 2020.
Right.
On 21st of April 2020, the Honorable Presiding Arbitrator had a fall, fell unconscious, and was admitted in the hospital.
Yes.
In that period goes from 21st of April 2020 until 28th of May 2020.
Right.
During this period, I'm not going into the detail, Malaj, but I'm just mentioning it. During this period, he was suffering from altered mentation.
Yes.
He was not oriented in space and time. If my lords want, I can actually refer to those pages which say so specifically. Those are there in my supplementary affidavit, volume 1.
All right.
He was suffering from altered mentation, Malaj. He had renal complications. He was COVID positive and he had a heart attack and he was on ventilator.
Yes.
He was also suffering from a neurological problem. He had a history of Parkinson's and he was suffering from a neurological problem. There is a terminology, encephalopathy, in the sense that when the oxygen doesn't reach the brain, there is an injury to the brain, which has a impact on the orientation of the person in space and time.
Yes.
So those details, if I can just, Malaj, just put this Honorable Court to the page numbers.
Please.
I am not taking my lords through to each
Understood.
one of them. My lords have already gone through that.
There's the page references.
Yes, just for the reference of the page, it's at page 8 of the supplementary affidavit, volume 1.
Yes.
It starts at page 8, Malad, and goes on until page 21.
Right.
Of the supplementary volume 1.
Yes.
So that is the first period of his stay in the hospital. And this is the time, Malaj should note, there was no notes of submissions which were made by the respondents herein even until at this point in time. The notes of submission from the opposite side is submitted only on 11th of June 2020.
Right.
The learned arbitrator is again hospitalized on 14th of June 2020 until 20th of July 2020. And
Yes.
even from 14th of June, Malaj, the noting in the 14th of June admission before in the hospital is that he had high fever 3 days prior thereto and was on bed rest. And eventually, Malaj, he's admitted in the hospital only on the 14th.
Yes.
The point I'm making is that he was unwell right from 11th of July itself, 11th of June itself, I'm sorry. So therefore, there couldn't have been an opportunity even for him at that point in time to prepare anything. Usually because, Malaj, what happens is that until both the sides don't submit, the writing or the deliberations or the reasoning doesn't start, Malaj. That is the usual practice. Even before the honorable courts, when both the sides submit their written submissions, it is then really that the application of mind starts. It's based on that aspect, Malaj. I am putting this chronology right from the 18th of January until 20th of July, how the things transpired. And therefore, the submission is that it was impossible. It was not possible for the learned presiding arbitrator to have actually written a 120-page award. And that too, it is he who is writing it, is the impression that has been given. My lords would remember the award is written in the first person. I
Yes.
hold.
Yes, I do. I do
After
remember.
after looking into the documents, I hold so and so. And this is, my lords, this is prevalent in the entire award. It's not as if one finding, two finding, but all that is there is in first person. The second stint on 14th, I'm just putting again the pointer, 14th of July and 14th of June until 20th of July, Malaj, he was again on bed rest. He had severe renal complications. He had upper respiratory tract infection. His kidneys were failing. He had tracheostomy done, Malaj. That's the tube which is there, which is inserted in the air tube for a person to breathe. And even for the food. And eventually, Malaj, when he was discharged for long domiciliary care. And he was discharged for 24/7 nursing instructions by the hospital. So therefore, the argument is, my lords, that the very grain and the thread of an arbitral award, which is underlying in the Arbitration Act, is consultation, participation by the two arbitrators or three arbitrators. Next, I'm going to come to the second point on three arbitrators, is at least for him to be oriented in space, time, physically present there, mentally capable to have written the award. And something, while it's very peculiar is to this award, is that there are last 2 pages of the award are a same copy. One is signed by the presiding arbitrator. The second is signed by the second arbitrator. So on one page, there is only a signature of the presiding arbitrator. And on the second page, there is a signature of the second arbitrator. That, my lords, is there. If my lords can just see that for a minute. That is there in my volume 6 of the supplementary affidavit, the last volume of the supplementary affidavit. And the signing pages are at page 829 and 830.
Yes.
So if my lords may see 829, only the presiding arbitrator signs. And please see the tense in which it has been passed. I accordingly disallow the claim of the respondent made on account of the cost of arbitration as made. I accordingly pass my award and deliver the same.
Yes, but Mr. Shindra, if it's the same in both pages,
Yes.
I mean, what are you trying to hint at? Because he
Yes,
just
yes. What
have
I-
omitted
so-
the first page. He's,
so sorry, Malad.
both of their signatures are there in the second page.
No, no,
Second last
absolutely. Absolutely right. So what I'm saying is that it was prepared by the presiding arbitrator is what the impression that is being given.
Yes, yes.
And it was first signed by the presiding arbitrator and then later on signed by the second arbitrator. So it can't be the case of the opposite side, that it is actually prepared by the second arbitrator and then agreed to by the first arbitrator.
Very well. Yes.
Because the first arbitrator or the second arbitrator is not saying that I've gone through the award I've gone through the award prepared by my brother and I agree with it. This could have been short-circuited by simply saying that yes, it is prepared by X person. I have gone through it and I'm agreeing to it. But that is not what has happened. What has happened is the impression that has been given is that it is prepared by the first arbitrator, the presiding
Yes,
arbitrator.
First person argument covers that.
Covers that. And
Yes.
what I wanted to show was that it is also signed by the first arbitrator first, and then signed by the second arbitrator. So it can't lie in the mouth of the other side to say that, oh, actually, it may have been prepared by someone else and then agreed to by the first arbitrator.
All right. Yes.
That is going to come from them on the basis of what they have submitted. So, my lords, my first argument, therefore, is Section 17. I'm not taking my lords through it. Section 17 of the Contract Act clearly says definition of fraud. Anything which to your knowledge is incorrect and is portrayed to be correct would cover fraud. So my argument is going to be that it was within the knowledge of the tribunal that the honorable presiding and my lords, these documents that I have got are of the medical documents. These are only after. These were not within my knowledge, my lords, at the time when the award was when the award was passed. So I had no means to discover or to put an application or to say anything at any point of time, except for making an application before this honorable court in an objection under Section 34.
True.
So therefore, the argument therefore is, my lords, first, that because either it has been filed on dotted lines, my lords, I don't know what has transpired inside the doors. All I can say on the basis of what is available to me, and all I can circumstantially point out to this honorable court is to say that this is not an award which can be called an arbitral award in the eyes of law. So that, my lords, is my first argument, which I'm not going into in great detail. I would, of course, be pointing out all those pages in my written submissions at the end of it, my lords. That, my lords, is the first argument. The second argument, an even interesting one, my lords, that according to me, the arbitral award is also hit by Section 31(2) of the Arbitration and Conciliation Act. Section 31(2) in substance says that if there is a tribunal of 3 arbitrators, the award must be signed by all 3 arbitrators, or if it is not signed by 3 arbitrators, the reason for omission of the signature must be mentioned in the award. It many a times, my lords, happens that even at the time, even when the honorable court of 3 or more judges is giving a decision, and if there is a dissent, the 2 honorable judges mention so in their own first judgment that we have shared, the honorable brother does not have the same view, and he's going to pronounce a different award. So, my lords, no indication of that sort in the majority award of 22nd of July 2020. Nowhere in the award it states.
On the contrary, in the minority award, it's indicated that he was not consulted.
Absolutely, my lords. On the contrary, in the minority award, at page 111 of volume 1, my lords,
Yes.
the honorable third arbitrator clearly says that I was just informed. I was just informed and I could not agree to it, and therefore I'm giving a different award. He was not even perhaps given a copy of the award. That's why there is a gap of 22nd of July, and the minority award comes only on 30th of July of 2020.
Yes.
If I can just, I'm so sorry, guys. If I can just draw my lord's attention to that portion at page 111, I'll just read it. My lords need not turn to that. On 22nd of July, I'm sorry, page 111, volume 1 of the main file, application file, the AP file.
Yes. Yes.
Page 111.
Everyone. Yes. I'm there.
I was only informed that presiding arbitrator and other co-arbitrators allowed claims of the claimant. Not being able to agree to such conclusion, I decided to write the separate. So it is not as if he was consulted prior to the making of the award, which is a sine qua non. There must be participation of all the arbitrators. Therefore, the legal argument is that there must be participation of all the arbitrators in the decision making, even at the stage of pronouncing the award. Not only during the time when the proceedings were taking place, and signing of the award, my lords, is not just a ministerial act. It is not only a procedural safeguard, but it is an imprimatur of the procedure that has been followed to reach to the award. And therefore the argument is, the majority award is against the very grain of arbitration per se, because the consultative process was not followed. Second, and the second important point, the third arbitrator was not actually a truly nominee arbitrator of mine, because he was appointed by the Honorable Court. He was not nominated per se. So he was appointed by the court, so therefore really an independent arbitrator. He was not my nominee arbitrator.
Otherwise, also he would be independent. I mean,
Of course.
but the insinuation also cannot be there. That
Absolutely. No, Maharaj, I'm not suggesting that.
No, understood. Let us
I'm
skip
not
that.
suggesting,
Yes.
yeah. But he's even perhaps on a higher footing for that.
Right.
Because he was appointed by the court, and he was therefore, had no role in appointment per se.
True.
Except for the court appointing him. So therefore,
Yes.
and I would give judgments of the Honorable Calcutta High Court, the Delhi, and of course the Supreme Court on all points. I'll submit a compilation of judgments. My lords would give me that indulgence. So the argument therefore is that because of violation of 31(2), the award is no award in the eyes of law. Even the majority award is no award in the eyes of law, because the consultative process was not followed. He was not asked to participate, neither was it communicated to him. Neither he had the opportunity. I put a question, Malaj. If he had known the award by the two arbitrators, he could have actually persuaded or tried to persuade the tribunal either this way or that way. They may not have agreed. That's a separate issue. But that opportunity of consultation, which is the sine qua non in section 31, is not, Malaj, it's not granted, and in fact expressly stated so by the minority arbitrator. So, Malaj, these are the arguments, two preliminary arguments on the point that the award ought not to be sustained. Now, Malaj, I go a step ahead in the point of questioning the merits per se within the contours of section 34. Therefore, Malaj, the third argument that I say is that my legal argument is that the arbitral award is contrary to the terms of the contract.
So 23 is also violated.
Yes, Malaj. It is contrary to the basic express terms of the award. I will just put my argument and then take my lords to the relevant portions. The argument is the contract provided for a guarantee of either 18 months from the date of commissioning or 24 months from the date of last supply of the machine. the tribunal has completely glossed over the second portion of this clause in the contract, which is clause 14. I would first take this honorable court to the finding, then to the clause, and then make my submission, my lords.
Mr. Chitra, can we look at the clause first and then?
Yes, yes, why not? Absolutely, my lords.
Suits you,
Absolutely. No difficulty. In fact, clause is reproduced in the contract in the majority award itself.
Then we can look at it from the award itself also.
Yes, yes, no difficulty.
Then let us go to the award.
Yes, yes, no difficulty, my lords. The award begins at, my lords would find the majority award
Yes.
in the AP file at page 20 is where it begins, my lords. And clause 14, my lords, may straight away come to page 104.
This is the GA file probably. Interlocutory file. Yes.
Yes,
Anyway, I've got it.
yeah.
No.
My lords, may please turn to page 104 straight away.
Yes.
The clause is reproduced at 105.
Right.
Now, this is a guarantee, but the contract was for supply of for supply, erection, and commissioning. Now, my lords, may please see clause 14.1 guarantee.
Yes.
For a period of 18 months from the date of successful commissioning or 24 months from the date of last dispatch of machinery, whichever is earlier. So, Malaj, two-pronged clause. Whichever is earlier from that, Malaj, the guarantee would start. It is the admitted date for both the parties of the date of supply of the machinery is 28th of December 2006. It's not disputed. I will take my lords to the relevant portion here also where it is supplied. Now, my lords, may please see, and in fact, this narration.
That was the date of last supply.
Yes. 28th of December 2006. According to us, that is also the date of commissioning.
All right.
That is what we say. The tribunal doesn't, the majority does not agree and says it was never commissioned. That my lords will see. And in fact, the narration at 104 to 111 is going to cover both my submission and merits.
All right.
So the argument, my lords, first is just to lay down the legal contours, is that the Honorable Tribunal has not looked into the latter part of the contract, the latter part of clause 14.1, and has completely glossed over it. And has only given a finding on successful commissioning, nothing else. So if I put it to myself, Malas, if it was not commissioned, let's assume it was not commissioned for a minute. The guarantee started for 24 months from the date of last supply. The date of last supply was 28th of December 2006. The guarantee only was validated until 28th of December 2008. The product has been rejected only in the year 2009. So no claim could have been made as per this guarantee clause, Malaj.
Yes.
And therefore the argument that take everything against me. Of course, I don't agree with the first argument also of successful commissioning. But I'm only on the point, in this argument, I'm only on the point that the latter portion of the guarantee clause has been completely glossed over, and the finding that has been granted is therefore contrary to the second portion of the clause of guarantee. completely.
Hmm.
And therefore, the award is contrary to the express terms per se. My lords, may now please turn, I will just now read from 104 to 111
Yes.
and then take my lords to some portions of the contract as to what was the definition of commissioning and what in clause 14 has not been looked into, and where I have argued this even from the arbitral award. So my lords, may please have a look at 104.
Yes.
I am starting somewhere from the bottom, my lords, all these facts. Third line from the bottom, all these facts established that the machine.
Yes. Got it.
And my lords can actually refer from right from page 104, the second paragraph, to analyze the basis of claims. I'm just skipping that portion, just coming straight away to all these facts. It contains the basic aspect that in December 2006 it was supplied. It continuously started giving trouble, and as a result whereof the same was not being able to run, and thereby it had failed to perform according to the terms of the contract. This-
Continuous complaints is the key phrase.
Yes, Malaj. That's my second argument, Malaj, actually. That's my second argument. Continuous is my second argument. There the argument is that you have added words to the contract. The word continuous is nowhere there in the entire contract. But for the purpose of this particular submission, what I'm stating is that despite me arguing to the point that you have not taken the latter part of clause 14 into consideration, there is no finding on it. Please see, Malaj, where I have argued that. Malaj, at page 69, I have specifically stated my argument. And page 88. Yes, 88 is rather better, Malaj.
Right.
Page 88 of the petition and 65 of the internal page, right on top.
Yes. Got it.
The rejection of the turbine, which was made by the claimant, was beyond the warranty period, and therefore the same was not permissible in law. The claimant has lost its right to reject the equipment for such a long period, and further by paying the cost of repairing and maintenance to the respondent from time to time. According to the respondent, there was no inherent defect in the turbine, and as such, no claim is maintainable against the respondent on such account. This is my argument, Malaj, at page 88, but it has not dealt with anywhere from page 104 to 111 at all.
So you say even if there were complaints,
Yes,
there was no specific rejection,
would
which
have
is
happened.
which is German for considering a guarantee clause.
Yes, Malaj, absolute. What I'm saying is that you could have rejected my claim, you could have rejected my machine only in the warranty period.
I may complain, I may whine about that, but whatever,
Everything.
I have to reject it. I have to refuse.
Absolutely. Your exercise of the right of guarantee, which according to you is cardinal to the contract, is for a period of 2 years, as per the contract agreed between the parties. This is an express condition, Malaj. That within 2 years, I will service, I will do whatever you require, but if you don't like it, if you want to reject it, in other words, if you want to claim extinction of price, you have to reject it within the period of 2 years. To compound to that, Malaj, in fact, I want to say there was actually a bank guarantee which was provided for the functioning of the machine. That bank guarantee was also not encashed within the period of 2 years. So whatever defect it may have,
All right.
you did not exercise.
Get you.
In other words, it was not an inherent defect per se. It couldn't be an inherent defect. If it was, you would have encashed. But you did not. That's the argument, Malaj. Now, Malaj, may please have a look at 104 to 111. This is really the crux of the basis of granting the claim. And on what basis? Please have a look at 104. I'm starting from the bottom.
Yes.
All these facts established and that the machine which was purchased for the claimant's purpose was not fulfilled. The said machine accordingly cannot be treated was commissioned in accordance with the guarantee clause as contained in the said contract. The guarantee clause was contained in the said contract has been referred to herein above. Nevertheless, the same is further produced below. It is stated, my lords, the word successful commissioning were the key factor for determination as to whether the said machine was erected by the respondent and had been commissioned. The successful commissioning, as mentioned in the said clause, would indicate that the machine after erection would go on for performing uninterruptedly and at least for 18 months, giving the rated capacity in accordance with the contract. In order to show non-performance of the machine and its failures to successfully run continuously, giving rated capacity, the claimant has annexed a chart in the statement of claim at page 293. I will take, my lords, to this chart in my subsequent argument to show that when and how long the said machine had run. The chart was also heavily relied on by the respondent in the course of their submission. From the said chart, it would appear that the detailed running of the said machine from 20th of January 2007 to 26th of February 2009. The third column of the chart indicates the major failure date, and fourth column of the chart shows about the total days of running. From the said chart, the first date of running is on 20th of January 2007, and it had run for 19 days, for a total of 19 days. Similarly, the other days of running have also been given in the said chart. It is significant that from the said chart, it appears that the said machine had run maximum for 80 days, that is from 30th of March 2007 to 2nd of July 2007. Rest of the days of performance, as shown in the said chart, are respectively for 17, 16, 9, 6, 3, 32, and 65 days. As already mentioned above, the respondent has also relied on the said chart and made submission in the course of their argument. They had also relied on the said chart in the course of evidence. So according to the respondent, there is no dispute with regard to showing continuous performance of the machine and for total number of days. If I analyze the said chart after taking into consideration of the maximum days of running, the said machine for 80 days from 30th of March 2007 to 2nd of July 2007, it would appear that previous running of the said machine was only for 19 days, that is from 22nd of January 7 to 12th of February 7. Yet the defects were found. Post running of the said machine of 80 days was from 29th of October 7 to 16th of November 7 for 17 days. Therefore, the chart undisputedly proved that the machine did not run successfully and continuously to give performance of rated capacity continuously for 18 months. Therefore, the running of the said machine as recorded in the chart cannot be treated as a satisfactory performance, and consequently it cannot be said that the said machine was successfully commissioned within the meaning of the said guarantee clause as quoted above. I therefore hold that the machine which was supplied by the respondent was incapable to perform according to the contract, and the same was also successfully commissioned as guaranteed for. This unsuccessful running and non-commissioning of the machine in accordance with the contract was a failure of obligation of the respondent under the contract and is a breach of the contract on its part. So nothing mentioned, my lords, of the second of the 24 months of delivery. While accepting the breach on the part of the respondent under the said guarantee clause as mentioned above, I hold that the claimant had proved categorically by referring to several letters, minutes of joint meeting of the parties as to the said breach of the contract by the respondent. After the same being proved by the claimant, the onus shifted on the respondent to disprove the same. The respondent has not been able to discharge its onus by negating the same. No independent document has been produced by the respondent to discharge the onus to the above said effect. I will say this is also incorrect, but that's a portion of my another argument. For this argument, I am not referring or detailing it. Since I have already heard that there was non-fulfillment of obligation on the part of respondent under the contract by not being able to commission the said machine successfully, and further, the said machine not being able to give the rated capacity, it was a breach on its part, which can also be treated as a breach of warranty. Then question arises, what would be the consequence of such breach of warranty? In this aspect, it can be said that in case of such breach of warranty, the parties affected become entitled to diminution or extinction of price. The claimant in the instant case has prayed for an extinction of price of 1,33,50,000 for turbine supplied by the respondent. This claim on account of extinction of price was made by the claimant by virtue of the said failure on the part of the respondent and its machine not being able to give satisfactory performance within the meaning of the said contract. The said claim was also made for further breach on the part of the respondent, that the respondent has not been able to commission the said machine successfully, as a result whereof the whole consideration failed. To assess basis of the claim on extinction of price, the claimant has considered the cost component as per the respondent's billing. Such claim has been made in para 44 of the statement of claim. One of my arguments is also going to be, Malaj, that this claim has been awarded over and above and beyond what is there on record. There is no record of 1,33,50,000. But that's a subject matter of another argument, Malaj. Right now, I'm not detailing that. But I'm just flagging it so that the Honorable Court need not have to read this again. This breakup of cost turbine, as given in the respondent's own bill, was followed by the claimant. There was no cross-examination by the respondent in this regard. Incorrect. Section 59 of the Sale of Goods Act has prescribed remedy for breach of warranty where there is a breach of warranty by the seller or where the buyer elects to treat any breach of the condition on the part of the seller as a breach of warranty. The buyer is, in addition to its right to reject the goods, may also set up against the seller the breach of warranty in diminution or extinction of price, or may sue the seller for damages for breach of warranty. Learned counsel, while arguing in support of the claimant's claim on account of extinction of price, has relied on sections 12 to 16 and 59 and 60 of the Sale of Goods Act. According to the learned counsel, the stipulation as contained in the contract between the parties with reference to the said TG set was a condition and or a warranty. According to the said provisions of the Sale of Goods Act, a warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives right to the claim for damages in addition to reject the goods. Similarly, under the said provision, the stipulation under the same is a condition of warranty shall depend on the construction of the contract. Under section 13 of the Act, when there is a condition in a contract to be fulfilled by the seller, if there is any breach, the buyer is entitled to waive the condition or elect the treat of breach of condition as a breach of warranty and not as a ground for treating the warranty as repudiated. Section 15, Manoj, that portion I'm skipping. I'm reading to in the instant case. It's about 6 lines from the top.
Yes. Got it.
In the instant case, the guarantee which was given, now this is the relevant part. In the instant case, the guarantee which was given under the contract was for successful commissioning of the machine, and such successful commissioning also implies that the machine would be able to run satisfactorily and continuously for 18 months to give rated capacity. However, it has been proved in no uncertain terms that the machine has not been able to function to give rated capacity under the contract, and consequently the same was not duly commissioned to give satisfactory performance. And as a result, the test of section 16 of the Act has not fulfilled. No mention of 24 months. They are only testing it on the aspect of commissioning. They are not saying at all, Malaj, that the guarantee, if it was not the logical conclusion of this, Malaj, of this discussion would have been to say, okay, if it was not commissioned, then for how long the guarantee is valid? If it was not commissioned, it was valid only for a period of 24 months from the date of supply. There is no mention of that, despite of me saying so and a specific argument being raised. So the tribunal can't gloss over, Malaj, the latter part and choose a particular portion and give an award on that aspect. The argument, therefore, is complete glossing over, complete disregard to the express terms of the contract.
Successful commissioning has been apparently mixed up with the dispatch also. I mean, these are two dissociated and different concepts.
Different concepts, Malaj. Successful
And
commissioning.
whichever is earlier, yes.
Yes, successful commissioning is only for the first part. The second part has nothing to do with successful commissioning.
Whichever sets in earlier,
Absolutely.
So here 24 months, I mean, in any event, 24 months set in. Even if there was no successful commissioning, then also due to apply.
Absolutely, Malaj. So dehorse the aspect of commissioning. Let's assume there was no commissioning and I just supplied the machine.
Even then,
your right was only for 24 months from the date of last dispatch.
Right.
And there is no dispute. I will show that portion also. There is no dispute that the last dispatch is 28th of December 2006 at all.
Right.
So that's my first argument, Malaj, on this aspect. Just to complete this narration, because this narration will also be helpful in my second argument. I'm just completing the narration. 109 Malaj have seen. Now, just the latter part of 109. Yes. While analyzing the terms of the contract, particularly the term commissioning, it can be seen that the term commissioning has been coupled with the expression successful. Therefore, commissioning does not mean merely putting a machine on the bed and running it, but it means in order to treat the same as commission. While considering this clause, commission in the light of the condition of commission as mentioned in contract, I can reasonably come to the conclusion that the said machine did not run satisfactorily for a continuous period of 18 months. I'm sorry, Malik.
Yes. No, I did not ask. Yeah.
I'm so sorry. There was an echo.
Something else. Yes.
18 months, and consequently, it was a successful commission as intended by the parties under the contract. Now, let's over the page at 111.
Yes.
These are the judgments that they relied on. Malad. Then 111. The last portion, it was therefore known to the respondent that if there was any malpractice of the machine, the entire unit of the claimant would suffer a lot. Keeping in mind of that consequence of the breach, the respondent was required to fulfill its obligation under the contract, contract which, however, it had failed. So this is the entire discussion on the aspect of commissioning, and there is no mention of clause 20, there is no mention of 24 months. That is the latter part of the clause 14 contract. So my argument therefore is, Malads, that if you don't take into consideration the entire contract or the second part of the clause 14, the award is palpably against the express terms of the contract.
Mr. Chinda, I would like to interfere here once.
Malad.
Was any concrete proof of the machines actually malfunctioning discussed in the award in any other place? That these are the expert report or something else of that sort, that the machines were malfunctioning?
No, Malad, this is the only, there is one report of Avant grade which has been put into place, but they say there is a problem with the turbine.
All right.
In that, I will take Malad to that also.
We'll look at that later.
Yes. There is one.
Yes, right.
But there is other than this reasoning, Malad, there is no other reasoning in the entire award.
The report has been considered anywhere in the award? Not the narrative that the report has been filed or they have argued on that. The award, the findings of the tribunal, is there anything of that sort that that report was looked into?
No. Not
probably that can be another ground for you, because Mr. Bagh is here for the other side. I'm just indicating to him also. Yes. Before it comes, he has to have a clue of that. Yes, very well.
Yeah.
Very well.
So that, to my knowledge, subject to correction, Manoj, I don't think it is there in the award. I'll still double check. But to my knowledge, right now, it's not been considered and stated so specifically in the award anyway, other than this explanation.
All right.
So therefore, Malaj, the second part has completely been not taken into consideration while making while I made the specific argument. Now, just 2-3 pages that my lords would be, it would be helpful for the court to note down, is the fact that it was supplied on 28th of December 2006 is very much there in the.
I want to see their admission.
Yes. I will show that.
Or discussion of their admission.
It's their claim. In the claim itself, I'll show.
Very well.
Yes.
Mr. Bagh, you agree to that? 28th of December 2006 was the last date of dispatch.
We have our submissions that we are not agreeable to that.
Very well. Please take
no
it.
difficulty.
Then Mr. Chinda, we'll have to look into that.
I'll show it right away, Malaj.
Yes.
Malaj, may please look at page 34 of this award itself.
Internal page 34 of the award, right?
No, Malaj. The 34 page number, internal page 11.
Very well.
Internal page 11 itself.
Got it.
It says at Roman number 18.
18.
Ultimately, on December 28, 2006, in the presence of respondent's representative, the turbine was delivered by the respondent to the claimant. So this is a finding, Malaj. This is what is stated in the award itself. Then, Malaj, may please have a look at 94 also of the same award.
Yes.
94, Malaj. I'm reading 1, 2, 3, 4, fourth line. The said machine, in fact, had supplied by the respondent in December of 2006.
Right.
Now, Malaj, may please see their pleading. 519 page number in volume 4 of the application file. Volume 4, I'm sorry. Yes. 519. Let me see.
Yes, 590. This is the
519, this is the statement of claim, Malaj. The statement of claim starts at 495
yes, yes.
and at 519 para 28.
Right, it's clear.
The
Yes.
turbine was finally delivered by the respondent to the claimant on 28th of December 2006. By a letter dated so and so, the claimant informed the respondent that the oil pressure and so on and so forth. But the factum of supply is very, very clear, Malaj. Then it is also, Malaj, noted in their cross-examination. Malaj, may please have a look at volume 10 of the application file, and it is at page number 1301. and 1306.
Yes. Question 237.
Yeah, 237, Manoj, may I have a look? So
Yes.
according to you, although the commissioning took place sometime on 28th of December 2006, the machine was running and the governor was found functioning properly and successfully until so and so date. When you detected the defect, do you agree? He says yes. So the commissioning on 28th of this is the cross-examination of CW1 their own witness ones. Please also refer to 1306 at 266. I
Yes.
am therefore suggesting to you that the turbo generator set required to be supplied under the contract was duly commissioned and installed by you as on December 20th, 2006. What do you have to say to that? He says, yes, the machine started functioning with those constraints on 28th December 2006. So the date of supply, Malaj, is very, very clear. I am going to, my second argument is going to be on submission, on commissioning. So that aspect is very clear, Malaj. It was supplied on 28th of December 2006. Now, Malaj, may please have a look at the fact just a minute. Malaj. Volume 4 at page 530. Yes. The date of rejection of the machine, I'm just showing that. The
Right.
date of rejection of the machine is 27th of July 2009. That is clear at page 530 of volume 4. 530, volume 4, para 41. The 10th
Yes,
line,
got
about
it.
7th, yes, Manoj. The claimant was compelled to treat such breach of condition as a breach of warranty of the turbine and gave notice of such fact to the respondent on 27th of July 2009. Now I will take my lodge to this letter of 27th of July 2009. This is the pleading. The letter is in volume 6, Malaj, of the file, of the AP file. Volume 6, page number 788. Yes.
Yes.
So my lords may see at 788, it is on this day that they finally reject, which is beyond 28th of December 2008. And they say, please take note. This is written by a particular gentleman from the other side who never entered into the witness box. 27th of July 2005, they say that, look, it is evident that the turbine suffers from defects, as in spite of repeated attempts to repair the same has not yielded results. Realizing this after so and so, even you have stopped taking further steps to repair the TG set, inasmuch as the supply, erection and commissioning of the TG set and its turbine capable of stable and continuous operation was the essential condition of the contract. The same has been breached in the circumstances as stated herein. Inasmuch as the turbine is incapable of suitable repairs and must therefore be replaced, we are obliged to treat your breach of the fundamental condition of the contract as a breach of warranty of at least the turbine. In the circumstances, we call upon you to refund the value of the turbine and put you on notice that we will also be claiming from you that it should be the difference, Malaks. It's wrongly written as defense of new turbine, which we must essentially purchase to salvage the rest of the TG set and consequently salvage our CPP. So the argument is, Malaks, this could not have happened post 24 months. It could have happened only within 24 months. And therefore, the claim was not initially itself sustainable per se, as per the contract. Then, my lords, the second argument for which my lords have already looked into the narration of the award. The reasoning in the award is that, look, it was not successfully commissioned. If we leave out the concept of the latter part and we still concentrate on the first part, there also, Malaj, the argument is that the arbitral tribunal, the legal argument is the arbitral tribunal has rewritten the contract. The arbitral tribunal has gone beyond what is written in the contract, and the interpretation of contract is so absurd. It is contrary to the express provision. Even on this count, I'll show you the definition of commissioning in the contract. It is contrary to the definition of commissioning. So this is the third argument, Manoj. I'm not confusing it with the first one. Even on the aspect of successful commissioning, the award is contrary to the term of commissioning in the contract, which I will show to this Honorable Court right now. And secondly, even otherwise, the interpretation is so absurd that it shocks the conscience of the court. It ought to shock the conscience of the court, and I would there be covered under the judgment of the Honorable Supreme Court. And
the conscience of the court, then you have
absolutely, Manoj, absolutely. It ought to shock is going to be my endeavor, subject to what this Honorable Court.
But the conscience of an obstinate judge is very hard to go. It depends on the judge. So let us come to the definition better than the conscience.
Yes, absolutely. But straight away. Now, Malas, may please have a look at the definition of commissioning at volume 5, portion of the contract at page 572. Yes. Page 572, Malas, internal page 21.
Yes.
1.4, scope of commissioning. Please see what is the scope of commissioning, Malas.
Yes.
Flushing, calibrating of instruments, testing and calibration of protection relays, meters, trial run, reliability run, safe handover for commercial operation. Safe handover of commercial operation and performance testing of equipment supplied. So this is the definition, Malaj, and scope of commissioning per se in the contract. Now they
But Mr. Shindra, yes, but another aspect is there. Successful is a prefix deliberately used in the contract also.
Yes.
Regarding the idea.
Yes.
So how do you, nothing can be disregarded as superfluous in a statute, less in a contract, but
yes.
also in a contract.
No, so therefore, I'm putting that.
This is commissioning, right? I agree.
Right.
Why should we say successful has to have something else?
Yes, because successful can't be continuous, Malaj. What they're saying is
Alright.
following.
All
What
right.
they're saying is following. What they're saying, the moment there is a break in functioning,
Right.
there is a new period of commissioning.
Then there would be no end to their
There
claims. I
will
mean,
be absolutely.
it's open-ended then.
Yeah,
Open-ended.
absolutely, Malaj. So, for example, if a screw is not there, if an oil is not filled, if there is a leak and the machine stops, it starts the next day, it will never be commissioned,
Or
ever.
even if there is some problem from their end also, then there would not be. And commissioning can be only a one-off incident. I mean,
Absolutely.
very well.
Absolutely, Malaj. It can't be a continuous period of 18 months running for 4,500 RPM for 24 hours from morning till evening.
Right.
So therefore the interpretation even otherwise is contrary to what is known as business efficacy interpretation of a contract, Malaj. First of course is a literal interpretation of the contract. If there is an ambiguity in the literal interpretation of the contract, then the business efficacy interpretation has to be adopted.
In fact, business efficacy is also covered by section 28 because it has to be the practice.
Absolutely. In the usage
usual
of
mode
trade.
of trade practice.
Yes. Usage of trade and trade practice. Absolutely, Malaj.
Very well.
So it can't be an absurd interpretation to the effect that the moment there is a break, a new commissioning period will start.
Very well.
Then they go on to eventually say that, oh, look, it was never commissioned, therefore.
Very well. Very well.
So therefore, even the second aspect, Malaj, according to me, first, of course, it is contrary to this, and successful cannot have the meaning of continuous.
Successful, the prefix cannot, I mean, extend or widen or broaden the meaning of the main term, which is it is prefixing.
Absolutely, Manoj.
So the
You
commission
can't overshadow. Yes.
it should
You
not overshadow.
Yeah, you can't overshadow or make the main term as superfluous. So the prefix actually, in their interpretation, gains so much importance, then the main term is really not heeded to in the contract itself. So that is my fourth argument, Manoj. In chronology, the fourth, and on merits, the second argument.
Very well. Yes.
Now there, Manoj, the Honorable Court has already seen that portion. Now, please have a look. What my lords are saying is actually resonated in the minority award at page 115. Please have a look at minority award, volume 1. Volume 1 at page 115.
Yes, 115.
Yes. Malaj, may now please have a look at this is the minority award. It starts, Malaj, at page, just give me a moment. Yes. It starts at page 50, 50.
50, yes.
Malaj, may just note on top, it is pronounced on 30th of July 2020. And at 115, please see. The claimant's case is that expression commissioning in the guarantee clause 14 meant successful commissioning of the TG, but in view of repeated...
I'm sorry, I did not get it. Page 115, you say?
Yes, Manoj. Page 115, it begins at para 29. Internal page 63 at the bottom. At the bottom, internal page 63. In volume 1 of the application file, Manoj.
Oh, it's page 86 in my copy. Running page 86, internal page 63 or 63?
63, Malaj. Internal page 63 begins with para 29 on top.
That's running page 86 in my copy.
I'm so sorry, Malaj. I don't know how we are different.
My friend is referring to volume 1 of the section 34 petition.
Oh,
yes, I'm referring to volume 1. Yes.
So let us refer to the internal pages.
I'm so sorry.
Because I was following from the GA. So
yes. I'm sorry, Malaj. This is here in the 34 petition. Yes.
No difficulty. Please go on referring to the internal pages. So
yes. Internal page 63.
Thank you, Mr. Bag. Yes. Got it, Mr. Chit.
Internal page 63, Malaj.
Yes.
Yes. The claimant's case is that the expression commissioning in the guarantee clause number 14 meant successful commissioning of the TG set, but in view of repeated need to decommission and recommission due to repairs, TG set and or turbine was never commissioned. And therefore, the respondent failed under the set term of the contract. Let me consider this case of the claimant for convenience. For convenience, the clauses set
I'm
out.
sorry, still I don't get it.
I'm sorry.
63 para?
Para 29, Malaj. Internal page 63, Malaj, it begins at
115 minute. Volume 1 of the section 34 petition.
34, Malaj. AP file, the application file. It would
What-
say AP number.
Anyway, then I must be looking at the wrong.
Page 115,
Yes,
paragraph
yes,
29.
So this is, I'll follow from the AP itself. I was some, that's it.
Sorry.
No difficulty. A115.
And Manoj, this is also relevant to just,
Yes, para 29.
yes.
Let's see.
Just to bounce back to my first point,
Yes.
that even the minority award did not have the access
No,
to-
that, yes.
to the majority award. And
Right.
that's why Manoj, the honorable third arbitrator is
Yes.
only referring to the arguments.
Uh-huh.
He-
Right.
He's not saying that, look, I have read the award and the award says XYZ and therefore I don't agree with it for so and so reason. He says claimant's claim is so and so expression in so and so, but
Yes.
in view of repeated need of decommissioning and recommissioning due to repairs, TG set and or turbine was never commissioned. And therefore the respondent failed under the set terms of the contract. Let me consider this case of the claimant for convenience, the clauses set out below. I'm not reading the clause, Manoj.
Mr.
It is
Chandra, I have underlined on the last occasion, so you can start from this argument is the adjectives.
Yes, in other words.
Yes. Let us start from the adjectives.
No difficulty, Manoj.
So,
So
they
I'm-
cannot be commissioning exactly the same logic as you are now saying. No
Yes.
commissioning over and over again. And
Yes, yes.
thing called
And it's-
continuous.
Yes,
Continuous, it cannot be continued. Right.
Yes, Manoj. Continuous or continuously, this clause as it stands, in my opinion, is plain, unambiguous, and efficacious to carry forward the agreement. The way the claimant interpret the clause, it would only lead to uncertainty. To add or subtract any word or expression in a contract term is impermissible in law. For these reasons, the claimant's case that there was no successful commissioning of the TG set by the respondent fails.
Right.
So, Manoj, that would not have been the interpretation, and it ought to. It can't be for any reason. I put a simple test of for an interpretation of a contract of a reasonable man, Manoj, of a reasonable man of common business efficacy. That this can't be an interpretation to the term of successful commissioning to mean 18 months of uncontroverted, unhindered supply. And in fact, in my second part of the argument that I'll come to, I will in fact take this honorable court to that very list, which demonstrate that it was functioning for a good number of periods. Now, it was successful or unsuccessful commissioning can't be the interpretation. The
So
fact
even in the notice, they refer to it being sent for repair,
that repair,
properly functioning and all.
absolutely, Manoj, absolutely.
They say it was functioning,
It was
improperly
functioning.
functioning.
Yes, it was
Apparently,
improperly.
something
Then
to
it was sent to you. Then you corrected it. Your
Yes.
people came, etc., etc. So therefore, clearly, commissioning had happened.
All right. All right.
Whether it was functioning properly or not is a separate aspect. But one can't say that there was no commissioning at all per se.
All right.
So completely perverse interpretation, Manoj, contrary to ordinary prudence and contrary to plain unambiguous language of the contract, which is the literal interpretation, the first rule, Manoj, and even contrary to the business efficacy rule, is going to be the second argument on
Right.
merit. Third, Manoj. Now I will shift to individual. This is really the substratum of the reasoning of the award, Manoj. Now I will shift to as to on what basis the claims have been granted. In as much as, Manoj, whether there was any material at all or not to substantiate those claims. That's the contour of 34, that if a claim is no claim in law, or if it is not unsubstantiated, then the court can look into it.
But there we are going into a very tricky zone because we cannot re-appreciate evidence and
Absolutely, Manoj. I am
we have to
mindful of
be
that.
very
Yes.
clear, perverse.
Yes, absolutely.
Was
Manoj.
there not looked into? We cannot go into the quality of the evidence.
Absolutely, Manoj. Absolutely. Not, I am not going to go into the quality. I'm going to, most of my arguments are going to be that this is a case of no evidence.
evidence. Very
Yes. Primarily, my argument is going to be no evidence, or my argument is going to be evidence not substantiated or evidence not proved or result from. That's going to be the argument.
Was
Now-
there a procedure agreed between you or the followed by the
No.
arbitral tribunal regarding tendering or nothing?
Not to my knowledge, Manoj.
Very
I will refer to my first few proceedings,
We can do that later on, no difficulty. Let us proceed for the time being.
yes,
is what we-
yes. So, Malaj, the first claim that has been awarded against me, which my lords have already gone through, is the claim of extinction of price. The claim that has been granted against me for extinction of price is to the amount of 1 crore 33 lakhs 50,000 rupees.
Yes.
Now, there, my lords, my argument is that this 1 crore 33 lakh 50,000 rupees is not borne out from any evidence whatsoever on record.
Hmm.
The invoice of the turbine that is on record is only for an amount of 40 lakh rupees.
But the tribunal, probably the majority award says that it's borne out from your bill or something like that.
That's right, Mala. So my bill doesn't say so.
Ah.
My bill nowhere refers to a figure of 1 crore 33 or a combined figure of 1 crore 33.
So let us see your watched bill.
Yes, Mala. Yes, absolutely. Now,
Yeah.
I will just show my lords first my refusal
Very
in the
good.
pleading where it is, their argument, and then I'll take straight away my lords to the bill.
Yes.
Now, my lords, may please see, first of all, my refusal to the petitioner's point that it is 1 crore 3350 lakhs. Please see volume number 6, page 829. Volume number 6 of the AP file, my lords,
Yes. Yes.
section 34. I'm sorry, volume 6, yes.
Yes.
Eight-
Yes.
29.
Right.
Now I say at para number 34, Malaj,
34.
I
Right.
say with reference to para 34 of the statement of claim, the cost of turbine supplied by the respondent is not 1 crore 33, but 40 lakhs. The question of being entitled to extinction of price or rupees 1 crore 3350 of the same in any event does not come and cannot arise. The respondent will also seek the details of the insurance claims raised and realized during the period of the operation. Now, please see their rejoinder at page 865 of volume 7.
Yes. Para 19.
Para 19, middle of the line. It will
Yes.
appear from the billing breakup provided by the respondent that the total cost of the turbine supply, including its auxiliary part, is 1 crore 3350. It is denied. I'm sorry. It is denied that any insurance claim. Just
Yes.
it is denied that any insurance claim has been made by the claimant.
Rest is denial. So
Yes.
they rely on a bill
On
for
yes.
turbine supply, including auxiliary parts.
Yes. Now, my lords, may please see. Please see the actual bill of the turbine for a minute. It's in volume 7, this very same volume,
Yes.
at page 943.
940, yes.
Yes. 943, Malaj. Please see steam turbine on base plate.
Yes,
The amount is 40 lakh rupees.
right.
And please see the billing breakup at page 940, 940.
Yes.
No, Malaj may first see 943.
943 first.
Yes, yes. Malaj may first see 943.
That's 40,000, 40 lakh. Yes.
That is 40 lakhs.
Yes, yes.
Now, please see the entire breakup.
There also it's corroborated.
Yes. Also, and by no combination, it is 1 crore 33 lakhs.
1 crore 33 lakh 50,000. Where do they get the amount?
I don't know, Malaj. That is what for them they had to clarify in their examination. They had to clarify in their affidavit of evidence. In
Mr.
fact,
Yes.
Malaj. In fact, I'll take my lords to their deposition also.
Mr. Chinde will start from there. I'll come back in 10 minutes.
All right, Malaj.
Continuing matter, item number 5 with the item number 6.
Wait, please.
Yes, please.
So Malaj, we were on the point of
Deposition clause.
deposition and 135, 1.35 crores is nowhere. I had shown my lords the breakup. I had shown my objection and their response to them. Now, my lords, please see straight away the deposition of CW1 in volume number 9. First three, I'm showing the affidavit of evidence first, and then the deposition.
Yes.
In volume 9, it is page number 1141, para 52.
Yes. Para 52.
It says, as per the billing breakup provided by the respondent, the cost of turbines supplied by it was 133.50.
This is their chief. This is their chief.
Yes, Malaj. This is
Right,
their
right,
chief.
right.
The chief begins at 1070, Malaj. This is their affidavit of evidence.
Yes.
It
No
begins at 1070. The relevant portion is at 114.
Yes.
And it says, having become entitled to extinction of price of the turbine supplied by the respondent, the claimant is as such entitled to and claims refund of the sum of rupees 133.50 paid to the respondent on account of the same. Now, Malaj, may please look at volume number 10, page 1295.
Yes, page 1295.
Yes, 1295, question 184. Now, Malaj had seen that particular paragraph, para 52. 184 is on the precise para 52.
Right.
On what basis are you deposing at page 72, para 52 of your evidence in chief that you are claiming refund of 133.50? Is it not a commercial matter? He says it is purely a commercial matter. I will not be able to give reply on this. As on the date, next question, Malaj, as on the date when the claimant made this claim, you were not in the employment of the claimant company. He says that is right. Page 1, para 186, he says, insofar as 53 of the same page, can you enlighten us on what basis you have deposed the aggregate cost of acquiring and commissioning the new turbine is rupees 366,310. Again, this is a commercial matter. I cannot throw any light on this issue.
Yes.
So Malaj, he is not able to show at all in his what is written in his deposition. There are two additional facts that Malaj must remember. During Malaj, this entire issue, the claimant and the respondent herein, the claimant there had actually ordered a new turbine from another agency. That turbine was ordered in 2008, much before rejection of my turbine, per se. So Malaj must bear that in mind. The cost, of course, of that turbine is reflected in question 186, is some 3 crore 66 lakhs or something like that.
They've also made a claim for that.
No, Malaj, they could not have, because they can only make a claim for difference. They made a claim, but they did not get that.
All right.
They made a claim, but they did not get it. But this current claim is not the claim of the difference. The current claim is the claim of the amount that was paid for that machine, which was my machine.
Yes.
Now, Malaj, may please look at the evidence of. Just have a look at the evidence of. Just Malaj, may give me just 1 second.
Yes, absolutely. CW1 was their only witness.
No, there were two witnesses, Malaj, CW1 and CW2. But CW1 has deposed for this fact.
Right.
Clearly. Malaj, may now please have a look at their second witness.
Hmm.
He also says something to that effect, but again, no explanation at all. Malaj, may have a look at volume number 7 of the file,
Yes.
of the AP file. Malaj, may look at page 906.
Yes.
Malaj, may have a look at 21 and 22.
Right.
21, he says, as per the billing backup provided by the respondent, the cost of the turbine supplied is 133.50. Therefore, the loss and damage suffered by the claimant is to the extent of rupees 1,67 lakhs, for which claimant is entitled to claim and claims from the respondent. The document evidencing the purchase of the new turbine and the schedule containing the details of the expenses and the cost incurred in purchasing of the new turbine in its erection, commissioning, and supervision have already been tendered at so and so. It is also pertinent to further note that all the expenses incurred in this connection are reflected in the ledger book maintained by the company in this regard, as well as the form statements prepared on the basis thereof. Copies of such ledger books and statements are collectively exhibited at so and so. These ledgers, books, and statements are a part of the record of the company, and I believe its content to be correct. Now, the very next paragraph. The claimant have purchased a new turbine and having thereby replaced the turbine supplied by the respondent is entitled to the claim of the extinction of the price of the turbine. The claimant is as such entitled to and claims the refund of the cost of the turbine supplied by the respondent, being rupees 133.50. Copies of the invoices with regard to the turbine that were raised by the respondent and paid by the claimant are annexed herewith and collectively referred to as 112. This 112, Malaj, is at page 940. This is the same document, Malaj, that my lord saw. At page 940 and at page 942. It's the exact same document.
Do they give the cost of their purchase price of the new turbine, the other turbine?
Yes, Malaj. That is, they say
Approximately, according to.
it's exhibit 102. Just let me.
So I'm trying to drive at whether 1,33,000.
Whether the difference in the new and the old price.
Then it has to be around 1,70,80. 1 crore 70,80.
Yeah, it can't be Malaj 1 crore. And that in any case is not their case, Malaj. They don't plead their case to be that please give me the difference between the old and the new turbine. Their case is you give me the refund of the amount that I have paid you per se.
Yes.
So they can't be given what has not been asked for per se.
All right.
So even on the extinction of price, Malaj, it is something that they don't. And in fact, one of their witnesses, he completely backs out. He says, I am not aware. I can't answer to this question of 133.50.
Because extinction is a very ambiguous term. I mean, extinction may mean
and Malaj, for
adjustment, may mean also other things.
This could not have been awarded for two reasons. Number one, the complete purchase price of the entire machine was not paid to me. In fact, one of my counterclaim was 38 lakhs is pending on me for the purchase price of the machine. So that 38 lakh 500 rupees was not paid to me out of the total amount of 3.4 crores. So the entire contract was for 3.4 odd crores, out of which turbine was a particular element. In any case, you could not have claimed the extinction because the entire money was not paid to me. That is number one. Number two, this turbine was never returned to me. They kept the turbine. So how can you ask for an extinction for whatever scrap it is worth, according to them? If it is scrap, the product had to be returned back to me. You can't keep the product and claim the difference extinction of price of the product as well. That you can't do, with respect, Malaj. So these two aspects were not taken into consideration. One of my counterclaims was that please pay me the pending amount in the counterclaim, which the minority award gives me. So extinction could not have been awarded for these two additional reasons, which have not been considered by them, Malaj, at all. So if I can just point out the pages for where my counterclaim is, and one important aspect, Malaj, the majority at page 108, the majority award, if my lords may have a look at that, page 108 says that, look, nobody was cross-examined on this aspect of 133.50. That is completely wrong. My lords, may please have a look at page 108 of the, I'm sorry, my lords, I'm referring to the GA file now. At page 108,
yes.
at the top,
No cross-examination, right?
yes, it says there was no cross-examination by the respondent in this regard. This is completely contrary to the record, Malaj. I have shown, my lords, the cross-examination of their CW1 on the point, and specifically on that point.
Yes.
Now, my lords, may please have a look. Okay, volume 9 and 10, my lords, have shown that. Just give me a second. Yes. So I have shown to the Honorable Court that even this finding is incorrect, because there is a clear cross-examination in which one of the witnesses gives up. He says, look, this is a commercial matter. I can't answer anything in that. And even on the rule, I'm not saying, well, it's strictly on the evidentiary, strictly on the basis of the way we lead evidence in the suits. But even otherwise, it is for them to substantiate their breakup of 133,500. It is not, even if I had not cross-examined them, but if on the paper they are not able to show how 133,500 is established, it's not going to be an admission per se on my part. Even though I am aware that section 19 of the Evidence Act, of the Arbitration Act, says Evidence Act doesn't apply, but on the basic concept of
Morality and basic principles of justice and all.
Perhaps.
Whichever we want to bring in by way of this, that window.
That's right.
Whatever is there in the law, if it does not directly apply, we bring it to that window. So understood.
So my counterclaim, Malaj, is at volume 7, page 835. Malaj, may just note that my counterclaim for 38 lakh rupees is at volume 7.
Can you give me the page number, please, once again?
Yes. Volume 7, page number 835.
Right.
I will just read that one. Just give me. There's so many volumes.
Page 834.
Page 835. Just to flag that point, I will take my lords to the minority award, which will deal and delve on it. I am just referring to page 835, which says what my counterclaim is. Yes, at para 41. The respondent counterclaim a sum of rupees 38 lakh on account of outstanding dues payable under the turbo generator set supplied by it. The respondent counterclaims against the claimant in this regard. The respondent is entitled to the entire actual cost of the arbitration proceedings, and so on and so forth. So I have claimed 38 lakhs for the non-payment of the award, non-payment of my product that has been supplied. Now, my lords, comes one of the biggest chunk of the amount that has been ordered against me on the point of, so the award does not only stop at extinction of price, the award goes up ahead
Hmm.
and awards damages pursuant to this, according to them, unsuccessful commissioning. That portion of the award, Manoj may first just see at page 125 to 129 of the GA file. I'm reading the award right now. And the amount, Manoj, that has been awarded against is me 7 crore 56 lakhs 75,000. So for a turbine, for an extinction of a turbine, which is according to them is of 1.35 crores, the damages that have been awarded against me is to the tune of 7.56 crores. I will show Manoj how they are wholly unsubstantiated and could not have been awarded. In other words, it's a case of no evidence per se. First, let's just understand, Manoj, on what basis the tribunal gives that award. Manoj, may now please come straight away to page 124 of the GA file. I'm reading the award, the majority award, internal page 101.
Yes.
At page 125, Manoj, 102, internal page 102, I'm starting from the bottom. There is a major claim.
Yes.
It says there is a major claim made by the claimant in this proceeding, that is on account of increase of cost of electrical energy and extra expenditure. This claim has been narrated in para 48 of the statement of claim. The detailed evidence in support of this claim have been given by the claimant's witness CW1 in para 55 and 56 of the affidavit of evidence. So they rely on CW1, who in his examination method states, I am not a commercial man, I can't give any evidence regarding commerce. But anyways, be that as it may, let's first read the award. This claim, according to the claimant, has arisen by reason of failure of the turbine to perform, which had prevented the claimant to utilize of the captive power plant till the new turbine was installed, which resulted sufferance of loss and damages by the claimant. In order to prevent sufferance of high electricity and fuel charges, the instant contract was entered into to purchase the TG set. The said TG set, which was supplied by the respondent, ultimately did not perform. The claimant could not get benefit of the said set and consequently went on incurring electrical energy of higher amount. The schedule containing the details of the increased cost of electrical energy has been produced by the claimant and has been exhibited as Exhibit 107. The claimant has also produced the bills raised by the Damodar Valley Corporation, from whom the claimant used to get the electrical energy, as Exhibit 114. Calculating in detail about the extra expenditure of high safety oil has been disclosed in the statement of claim and has been marked as Exhibit 108. The claimant has also referred to document being ledger showing the expenses incurred on such account being Exhibit 115. The claimant's case is that high expenditure on account of electrical energy could be reduced only after installation of the new machine after 8th of June 2010 from 9.43 rupees per kilowatt to 2.57 rupees per kilowatt. The evidence in this regard of CW1 and CW2 was placed. It is evident from the record that no cross-examination was made by the respondent on this document, which is wrong, Malaj. I'll show the cross-examination. According to the claimant, that the claim of damages on this account was directly a result of failure of the respondent's turbine. Against this claim, the respondent's contention was that annexing DVC's bills and the ledger amount being Exhibit 107 and 108 are meaningless. The respondent's contention was that the claimant has not proved the said claim of 7.56 crores. According to the respondent, there is no proof of payment to DVC as allegedly made by the claimant. According to the respondent, the claim of the claimant on account of increased cost of electrical energy is baseless. Considering the above contention and counter contention of the parties with regard to the claim on account of increased cost of electrical energy, and after considering the document relied on and the evidence led in respect thereof, I come to the finding that since admittedly the machine did not run satisfactorily after erection on 28 December 2006, naturally, the electricity could not be produced out of that, for which the main object of the claimant for entering into the said contract with the respondent. It is also to be considered that the electrical energy was required by the claimant not for distributing of the same to other consumers, but for its own use in its plant at Durgapur. Therefore, such energy was a most important factor to make the said unit of the claimant running continuously and with minimum cost. The claimant, however, was not made any claim for damages for it not being able to run the plant and consequent damages thereto. It has claimed only the money which it had incurred to make its unit running by paying extra and or more expenditure to buy electricity from DVC and an account of cost of diesel. I have already held that the machine had failed to perform according to the contract, and accordingly the claimant has become entitled to get the extinction of price. If that becomes the position in fact and law, then automatically the question would arise as to whether, by reason of such non-performance of the machine supplied by the respondent, the claimant, in addition to extinction of price, would be entitled to claim any damages from the respondent. Here in the instant case, the damages is claimed not in the nature of loss of profit, but on account of increasing extra expense of buying energy, which the claimant could have avoided had the machine run effectively and in accordance with the parameters contained in the contract. I accordingly hold that the claimant would become entitled to claim the damages by way of increased cost of electrical energy as claimed in Prayer D. In this connection, I may refer to claimant's contention that the claimant could ascertain the extra cost which was incurred only after installation of the new turbine on 8th of January 2010. According to the claimant, such money could have been reduced from 9.43 rupees per kilowatt to 2.57 rupees per kilowatt. If I accept this figure as given by the claimant, then I must come to the conclusion that if DG set which was supplied by the respondent could function properly and in accordance with the contract, the claimant could have incurred expenses on account of electrical energy at a reduced price. As mentioned above, the claimant in support of its claim on account of extra cost incurred for energy and diesel has exhibited 3 documents, being Exhibit 107, 8 and 50, showing details of such expenditure. The Annexure L indicates the cost of minimum contract demand with DVC as rupees 4 crore 67,020 lakhs. 4 crore 67 lakhs 20,000. Therefore, if the total consumption of electricity is calculated from the cost of minimum contract demand, it would appear that there was extra expenses incurred by the claimant. Simultaneously, the claimant had also given details of the expenses incurred on account of diesel oil in running of generator set. I do not find that there is any cross-examination effectively made by the respondent to the claimant's witness on such account. This is again false, Malaj, I'll show. Without having any contra evidence from the respondent against such claim of the claimant on account of extra expenses, I accept the said claim of the claimant of rupees 56,75,686 as claimed in Prayer C of the statement of claim and pass an award of such amount in its favor and as against the respondent. Now, let's over the page at page 108. The next 2 portions are in relation to points which are not granted to them. Just see at 108 and at page 131. I am referring to the table, Malaj.
Yes.
This is the amount which has been granted, and please see on account of increased cost of electrical energy and extra expenditure of the high-speed diesel, an amount of 7.56 crores has been asked for and it has been granted. So 3 claims are granted against me, Malaj. The extinction of price, the repairs and maintenance, And the fourth, that is the on account of increased electrical energy and extra cost of high speed diesel oil incurred by the clinker. Now, Malaj,
Mr.
my
Chinda, I require a clarification on the concept. I mean, this turbine was used.
Malaj.
They have some energy as a byproduct. I mean, they manufacture steel or something else. I mean, metallics.
They manufacture pig iron, Malaj.
Pig iron. Very well.
For manufacturing of the pig iron, they need electricity to be produced. They
Right.
need electricity.
So they have some captive energy which they want to convert by virtue of this turbine.
So what happens is, Malaj, they already have a connection from the Damodar Valley Corporation
Yes.
for
yes.
the electricity.
Some
But
of their
you know-
captive energy, if that is also converted, then they require less from DVC.
Yes, that's the point, Malaj.
All right.
So
Did
the
this establish that what was being used before and after and all this?
So what the purpose for which, according to them, they bought or they wanted to make this plant
Yes.
was to reduce their dependency on DVC
Right.
and produce the energy domestically that they require.
Rather convert their own captive sources. I mean,
Yes.
Yes,
It's like a
yes.
captive power plant.
captive power. Right.
Yeah.
Right.
It's just that the electricity in this was being produced by steam
True.
instead of coal and those. It is produced by
But they
steam.
get to reduce the costs.
Yes. That's the idea, Manoj. The
Right.
idea was to make electricity indigenously, use it in it, reduce their dependency, and so on and so forth. That is what the purpose, according to them, was.
Yes.
That we will put it, use it, and finish it.
Is there any material on record to show what they because they admittedly purchased some turbine later on?
Yes.
So after that, what was the reduction? Is there anything on record or any discussion on that?
No, only the witness comes on record and says that this is the reduction. But other than that, Manoj, the quality of the evidence that has been led, not even quality, I'm saying the evidence that has been led per se is no evidence in the eyes of law at all, number one. Number two, they have been cross-examined and one of the key witnesses abandoned post. He says, I'm sorry, these are commercial matters. I can't say anything about it. And please look at it this way, Manoj. They are palming off the entire DVC corporation bills during the period of 2006 to 2008 onto the petitioner.
That
They are
was my
saying whatever
question
electricity-
actually. That was my question actually. Did they show anything to indicate that this was the reduction? I mean, if they had the
Manoj, so-
turbine, this was
No. So in fact, we posed a question to them in their cross-examination that
Yes.
even before and even afterwards, even after
Right.
2010,
Yes.
the DVC connection is still there.
No, connection remaining there and the consumption is different.
Yes.
With the
So
consumption,
in fact, the consumption also, their witness was cross-examined for the relevant period of their own profit and loss statement in saying what
Yes.
was your
Basis.
yes. So what was your basis? Yes. To which he was not able to answer.
right.
He did not, in the profit and loss statement, they were not able to show their expenses towards fuel and energy, even during the relevant period. So the point being, Malaj, that their dependency on DVC and how much was decrease and increase.
That is my
is
question
not-
actually.
No, is not established in law. They were not able to show that during the period post 2010, our consumption with the DVC has reduced this much.
Yes, because if it is not their case that their entire energy needs would be supplied by the captive power,
Yes.
obviously it is not because the
They-
DVC
it's-
connection
it-
was there before and after.
It can't
So
be.
then
Manoj.
they probably had to show the difference,
Yes, absolutely. So that
which,
difference.
regarding which there is nothing according to you.
Yes, they basically come and record and say the amount was reduced from 9 rupees to 2 rupees. That's all.
Their case, but
That is
have they
their case.
established? Yes, because then they produce the entire bills of the DVC for the relevant period. That also I can understand.
That's right.
But what would
But
have
they
been?
don't give a comparative. They don't give a comparison between how it was earlier dependency was this much and post the dependency has reduced or decreased this much.
All right.
That I have not seen from either of the two witnesses.
Very well.
Right. So Malaj, there with that, now please refer to the kind of, and this is going to be the major part of both the examination of both the two witnesses. because I am going to take my lots through the statement, the deposition, the material, and the cross-examination. Because this kind of claim of 7.56 is
Show
of
me the
course
relevant portions, Mr. Chindra, which the
Yes, yes.
ones which may go against you the most. Because
yes.
this is not a section 96 CPC
No,
appeal.
no,
so
of course, but I
So
will
there's
not.
the-
Yes, absolutely. The way I've tended, the way I've gone through in other matter
Exactly.
in
Exactly.
other matters, I'll go in the same way, Malaj.
Please.
So yes, Malaj may first turn to Mr. CW1's evidence, Mr. Kesharwani's evidence. And that is at exhibit 107. Malaj may first, yes, Malaj may first refer to Malaj may first refer to CW1's evidence, my lords would find in supplementary affidavit, volume 4. Supplementary affidavit.
6টা দিয়েছিল। Yes. Yes, please.
It starts at page 453, my lords. Sorry, it starts at another position, but the portion is at 453. The relevant portion for this claim is at 453.
This is a continuation of the affidavit in chief of the CW1.
Yes, Malaj, yes. In CW1's chief. Malaj, may please have a look at para 55 first. At 453, internal page 74.
Yes.
Malaj, has that? Although it was originally agreed that the respondent would manufacture, supply, erection, and commission.
Yes, please.
Yes. Although it was originally agreed that the respondent would manufacture, supply, erection, and commission of the turbo generator set by September 2005, in the circumstances stated herein above, the claimant was compelled to repeatedly extend the timeline for the respondent to manufacture, supply, and erect the commission of the same. Even as per the respondent itself, it was obligated to complete the commissioning by 28 December. As has been stated herein above, the respondent, however, failed to duly commission the turbo generator set, for which the claimant was ultimately obliged to purchase the replacement turbine for an alternate source. Such replacement turbine was manufactured and was thereafter erected and commissioned on 8th of January, whereupon stabilized operation was attained. In the circumstances, it is only thereafter that the claimant could reduce its per unit cost of electricity from 9.43 to 2.57 and further reduce the regular expenditure on the high-speed diesel oil for its diesel generator sets. Although even after taking into account the extensions granted to the respondent, such saving of cost should have been available to the claimant from 28th of December 2006 by reason of the respondent's failure to duly commission the turbo generator set and further by reason of the inherent defects in its turbine requiring the same to be replaced. The claimant could avail of such savings in costs only on and from 8th of January 2010. As a consequence, by reason of the breaches and latches of the respondent, including breach of the fundamental condition of supply and of the warranty, particularly of the turbine, the claimant suffered the loss and damages on account of increased cost of electrical energy is rupees 2,64,16,567, an extra expenditure on high-speed diesel oil of rupees 4,92 aggregating to 7.56, for which it is entitled to be compensated. A schedule containing the particulars of computation of the loss on account of increased cost of electrical energy is exhibited in the instant proceedings, and further a schedule containing the cost of extra expenditure of the high-speed diesel oil for the period of so and so till December 2019 is also exhibited in the instant proceedings. So no exhibits, Malaj, pertaining to how much was their increase or decrease in consumption post 8th of January 2010. All of their evidence is in relation to the consumption during that period, the electricity consumption as well as the diesel consumption during that period.
There is not a single electricity bill produced after 8th of January 2010.
No, Malaj. I will show. I will
Hmm.
show from there on record. So now just have a look at the exhibit. Now please have a look at their exhibits of those three exhibits that the arbitrator talked about, exhibit 107, 108, and 114. Please have a look at 107, which is at volume number 6 of the arbitration petition of the section 34 petition.
Volume 6.
Yeah. It is also there, Malaj. Just don't refer to the that.
no.
Malaj.
No
Malaj may
difficulty. I
refer
have.
to, Malaj may refer to supplementary affidavit. Volume
No,
5.
no. Volume 6 is of AP is fine.
Yeah, but there is also a volume 5 of the supplementary affidavit. What my lord was looking at right now was a volume 4 of supplementary affidavit.
Very
Just
good.
have a look at volume 5 of the supplementary affidavit.
All right. Yes.
In volume 5 of the supplementary affidavit, my lords may please look at page number 681.
Yes.
So my lords may look. So in fact, my lords, those bills are also there from 8 and 9 onwards to 9 and 10. The DVC bills. Just have a look at the annexure first.
Which page?
Page 681, Malaj.
681. Yes, I am there.
Yes. So this is the table, Malaj.
Yes.
This is exhibit 107.
This is the table of the electricity expenditure.
This is the table of the amount of money they, according to
Paid.
them, the bills which were generated by the DVC from 2006-7 to 10 to 9-10.
Hmm.
So now this document of which they are attributing the amount to me is backed up according to them by exhibit 114. Those are the bills of Damodar Valley Corporation. Exhibit 114, my lords would actually find at. Just give me 1 second. Okay. Yes. Exhibit 114 is in the other witnesses statement. That is at page number volume 7 of the section 34 petition at page 970.
Nine seven zero.
9701.
Yes.
So they say this is exhibit 114. They say on top documents in connection with annexure L.
Ah.
Now please see, Malaj, what has been attributed to me is the entire cost.
Yes.
At 970, the amount that has been gross bill amount is 34 lakhs. That is what is entered in the schedule at 681.
Hmm.
And the witness to this statement, he resides from this 681, Malaj. He says it is not made by me. I will show that. But be that as it may, The point is the entire demand of Damodar Valley Corporation is being palmed off to me.
Hmm.
It is not their case, Malaj, that the Damodar Valley Corporation's connection was going to be disconnected. That we never wanted the Damodar Valley Corporation connection.
Hmm.
But each amount of the bill is being palmed off to me from 2006 to 2009. And please see their consumption in 2009 and 2010 as per their own evidence. It is steadily increasing on Damodar Valley Corporation.
Hmm.
As per their own record, Malus, please see 8, 9, 9, 10. It is coming up to it is increasing to 12 crore, 1.2 crores, 1.4, 2.9 crores, 2.9, 3.4, 4.4. I don't want to rely on that because anyways, they have not proved this.
Hmm.
But the point is, you can't palm off the entire Damodar Valley Corporation bill onto me.
Hmm.
And please see, Manoj, now please see the cross-examination of the relevant witness. The person who produces this 681 is CW1, Manoj. Now please see his cross-examination. Please see volume 10 of the section 34 petition. Manoj, may first look at 1288.
Yes.
1288, Manoj may look at straight away. And question number 132 and 133.
Yes.
Now, please see, he says, Mr. Keshavani, please refer to your answers to so-and-so given on earlier occasion. You have first stated in so-and-so that all the information related to are true to your knowledge. Subsequently, in answer to question number so-and-so, you have stated that you have not consulted the ledgers and books of accounts in preparation of the statement mentioned therein. Do you see a contradiction there? Actually, I was fully responsible for all these technical matters. All these matters were related to commercial things. That is the reason why I have replied this. So in respect of any commercial matters, you cannot have any personal knowledge. Answer is yes, sir. On commercial aspect, I will not be able to give any reply per se. Please refer to question number 138 on the next page, madam.
Yes.
What do you mean by that? Actually, what happened after that, when I left the organization, if there was anything written in any document, that can be verified only through the records. 139. What the learned counsel is asking you, how far the statement contained in your deposition are true to your knowledge and how much of them is not true to your knowledge. Before my leaving the organization, whatever things happened and whatever I have come across, those are written by me. Documents on which my signatures are there, those are true to my knowledge. But after that, it can be verified only through the records because I was not present there after 11th of October 2007. So even the rejection of the turbine mallards did not happen in front of him.
What is the designation of this witness? He's a sort of
Yes.
accountant or something of
He's
accountant.
a technical guy, Malaj.
What's the project?
Kesharwani is a technical guy.
Hmm.
Now please see straight away the relevant question on this aspect. Just one more question, 147 and 149 on the next page, 1290.
Yes.
So your evidence before this tribunal, I'm reading 147. So your evidence before this tribunal regarding the matter that happened after October 17, 2007 cannot be true to your knowledge and you cannot have any personal knowledge of what happened after 11th of October. That statement is true. Even with regard to non-technical that you have gone on deposing in this affidavit in chief, you cannot have any personal knowledge. That is true. Do you realize the consequence of making an untrue statement before the tribunal? He says yes. Still you wish to stand by this affidavit on evidence? He says yes. Now please refer to straight away question 795 at 1377. Page number 1377. This is exactly on the exhibits.
Hmm.
Thirteen 1377. Please see question number 795. It is exactly on 107.
Hmm.
Kindly take exhibit 107 and tell the learned tribunal as to what this document is about. Is it again related to commercial matter? He says it is again related to commercial matters. So I take it that you do not have any personal knowledge of the contents of this document. He says that is right. So 107, Malaj, he does not stand by exhibit 107. He says these documents are not produced by me. These were, I can't say anything about this. So the primary document of 107 on the basis of which I am fostered a liability of 4.9 crores.
Hmm.
That is completely disproved, Malaj. Is not even, forget about the weight of evidence, Malaj. The witness who is tendering it says, I can't say anything about it. I am sorry. Please see for 108 also. I won't show the tribunal again. I won't show the Honorable Court again these two questions. Even for 108, 108 is for the purposes of the diesel expenditure. There they say, kindly take exhibit 108 at page 307. Tell the learned arbitrators as to what is this document. He says again a commercial matter. So you do not have any personal knowledge of the contents of this document. He says no, that is right. So Malaj, on the aspect of the bills of Damodar Valley Corporation, the discrepancy is twofold. One, that the entire amount of DVC is being palmed off without any justification. There is no justification in the evidence that had we had the correct turbine, the amount would have been reduced to this much, as a result of which the balance of the Damodar Valley Corporation, we consume so much more electricity from Damodar Valley Corporation, and therefore it would have been, therefore it is because of your default. That kind of evidence is not there, number one. Number two, Malaj, there is no mitigation according to them. According to us, there is no mitigation at all. Now, please see, Malaj, the kind of evidence that they leave for diesel expenses. Please see, Malaj, the exhibit of Kesharwani at page 797 of volume 6.
This will be the supplementary affidavit or?
In the supplementary affidavit, Malaj can look at 682. In the supplementary affidavit, volume 5, Malaj can look at 682 straight away.
Yes. 682, right?
Yes.
This is exhibit 108.
It's exhibit 108. This is, Malaj, in reference to the consumption of diesel. They say that, look, we not only took the electricity from DVC,
Diesel also.
but we ran
ICP.
our own generator sets
Yes.
to supply energy to us, to supply electricity to us through generator sets. And for using of those generator sets, these are the diesel. This is the diesel that we have used.
Hmm.
Now, as per 108, of course, Malaj, 108 was resiled from, which I showed this honorable court just before. In Keshwani's evidence at page 7, at the document that I just showed, he resiles from 108 also, Malaz. He says these are commercial matters. I can't comment anything. This is not my personal knowledge. I'm sorry. So he doesn't stand by this document at all. And the amount that is being claimed, Malaz, is 4.9 and 2.4 there. And please see, Malaj, what is the basis of preparation of this? So he resides from this document completely. The second witness, who is Ashok Kumar Agarwal, please see his exhibit at volume 8 at 1006 page number. Volume 8, Malaz.
Exhibit 115.
I'm sorry, Malaz.
Exhibit 115.
Yes, exhibit 115.
Yes.
Yeah. 1006 at page volume 8. Just give me. Yes. Yes, 1006. Now, please see, Malaj, the kind of material that is there. These are their internal ledgers, Malaj. This is not sent to me or countersigned by me. These are their internal ledgers running from 1006 up until 1064.
Right.
These are all internal ledgers. No bank account statement, nothing produced. And a specific question is posed to him. That can you produce any underlines of this? He says, no, I'm sorry, I can't.
All right.
Please see, Malaj. Please see volume 11 at page 1423. Questions 248 and 249.
Right.
So, Malaj, the cross-examination starts at 244 on the relevant point.
This is CW1 or 2?
This is CW2, Malaj. This is
2,
Ashok
right.
Kumar Agarwal. Yes.
Right.
This is CW2. The 64 pages that I showed this honorable court is asked, referring to the pages in 244. Kindly tell the tribunal as to who has prepared the documents appearing in page 105 to 165. So he says these are printout of different ledgers as per maintained by the accounts department of the company. Please look at, now straight away come to 248. The question put to is, have you disclosed any supporting document to the entries in the so-called ledgers? I do not remember. I will have to go through and record to answer this question. I suggest to you that there are no such supporting documents. He says, I do not agree. But there are no documents in support of these ledgers on record. So, Malaj, internal documents, you can do whatever you want. When the underlyings are asked for, the underlyings are not produced to this document. So, on this kind of evidence of one chart which has been produced before the tribunal and a ledger with no underlying, can an amount can any amount, have they discharged their burden at all of proof from any standard? Forget preponderance of probability, but from any standard. Otherwise, Malaj, internal documents, I'll make whatever I want and I'll put it. And also, please look at their exhibit 108. I'm not relying on it, but just have a look at 108. Even according to them, after the installation,
Yes.
there is use of this from January of 2000. They have not given that. Even in March, there is a use of the diesel per se. And even the Damodar Valley Corporation is not just silent, Malaj. It's not as if the Damodar Valley Corporation post 2009 and until January, there was no consumption at all. And in fact, these witnesses were cross-examined specifically, and some documents were tendered by me. I'll show that, Malaj, perhaps on the next occasion. I'll show the evidence that I positively led, which was not considered by the tribunal. And the cross-questioning with these witnesses,
No, you positively led what evidence? The bills before and after. I mean, after this.
I led the evidence. I led the evidence of their own profit and loss account statement.
After this January 20.
Previous and after, yes, my lords. Prior to and after. On the next occasion, Malaj, my inquiry will be, my probe will be primarily to show the lack in their statements. I will be referring to their affidavit of evidence and these statements a little more. What the evidence I led, and what is the view of the minority and on what basis. And then, Malaj, I'll submit the law. I will just take a day on the law. That's about it. And then, Malaj, it is over to the opposite side.
So you'd like to end there today, Mr.
I'm so sorry, Malaj.
You'd like to end there today?
It's better, Malaj, than otherwise I'm beginning on a new string.
New
A continuity will be maintained.
Very good. So we'll put it in a list on next Friday, actually.
Yes, next Friday is Malaj, the
31st.
Yes.
Very good. Heard learned counsel for the petitioner, who for further hearing, let the matter stand over till October 31, 2025.
Could it be, Malaj, instead of 31st, 7th?
7th, this court may rise early for some official work.
Okay.
So it has to go to 14th.
If it's comfortable, Malaj, can we consider 14th? Or
14th, yes, subject to it. Very good, 14th.
I'm obliged.
November 14, 2025.
Yes.
Thank
you. I'm obliged.
Thank you.
Deeply obliged.
Supplementary আর mix হয়ে যাবে। এগুলো আজকের গুলো একটা স্টেপল করে আলাদা রেখে। হ্যাঁ, আজকে স্টেপল প্রত্যেক দিনেরটা স্টেপল করে আলাদা করে রাখবে। মানে অ্যাকশনই করে এখানেই রাখবে, কিন্তু উপরে থাকবে লাস্ট দিনটা। পরে ঠিক আছে, করেন সাজিন।
এগুলো একটা করুন। Item number 7.
You are for the petition and you are arguing on that.
I am
for the petition.
appearing on behalf of the respondent.
Milord,
Respondent number 1, the developer in this application.
You are arguing still.
yes, Milord, we are yet to place, Milord. The thing is, Milord,
May I, Milord,
there is an
make one
application.
humble submission?
There is an application preferred by my learned friend.
What is that?
Milord, my humble submission is, Milord, essentially the dispute is with respect to a development agreement, whether the developer is ready and willing to give the allotted portion to the owner. That is, my lord, my short understanding in a very short ambit. But we have written to them this year in January that the units which are entitled to them, it's ready, and we are ready and willing to hand over the same to them. This is our letter.
We
they
have
have replied
replied
to
to
that
that
also.
letter. Firstly, my lord,
Just a moment, a very small moment. And they have kindly, it's a very short letter, my lord. And we have said that we are ready and willing to hand over those, my lord, units which fall in their allocation to them. This is
What do you say
basically
to
the
that?
crux.
Yes.
My lord, to that they have replied, and they have said that they will be paying us the money at the time of registration, and they do not intend to pay any interest, which may be one of the contractual terms, because they say that it is not to be blamed upon them. Now, this issue, the main issue, my lord, is taken care of. The building is constructed, and their units, my lord, are free and ready. The issue which may be left is, my lord, what is the amount they will be paying, whether they will be asked to pay the interest as per the terms of the contract or not. My lord, I most humbly say this is an issue which can be settled even by the exercise of mediation, because now we are in a better position. Main issue is taken care of.
Yes, what do you say to that? That
Let's-
seems to be a fair suggestion.
we have actually, that
Let
is
us
the
send it to
letter, my
mediation
lord,
then.
dated 17th January. We have replied to that on 6th February. My lord, two issues, my lord. The unit that we have purchased, it's not reflecting the correct number.
So we can direct these are flats.
These are flats.
The flats to be handed to flats or apartments, whatever, to be handed over to you, subject to you paying the rest, balance amount, keeping open the question of interest, payability of interest.
My
If
lord,
that is the bone
that
of
is
contention.
one question, my
I
lord.
may
The
ask
other
for
thing
it.
is,
I may waive it as well.
Yes. So let us
Milord,
send
that
it to
is-
mediation
that
on
is-
that.
Take instructions and come back on the next.
my lords, the construction that they have said in their letter, they've said that they're ready to hand over right now. This is a 2014 agreement
right,
for
right.
sale where I had put in
So
14 crore
what is your
rupees.
take on that?
My lords, on the point of settlement, my lord, I will have to take instructions, my lord, but there are also other disputes, my lord. If your lordship keeps it for the next week, if I may come back and address on
May I
this
make
point.
one humble suggestion, my
I
lord?
believe there are other parties also, my lord, who are
May I make one
contesting.
humble suggestion? Your lordship so pleases, your lordship, my lord, can keep it for mediation. We'll come back anytime in November end.
No.
This
We'll
is a
take
very small aspect, and this
So
aspect, my lord,
November would not be enough time for the
Or
mediation.
or first week of
Mediation,
December,
the mediator has 60 days in any event.
or first week of December, my lord, because the main issue, and I repeat myself, my lord, was the
No, let us take
building
instructions.
construction
Let them take instructions on the settlement aspect at all.
as your lordship feels.
Learned counsel appearing for the respondent hands over a photocopy of a.
My lord, I am appearing on behalf of the respondent number 1.
Sorry.
That is the developer.
Learned counsel appearing for the respondent number 1 stroke developer submits by placing reliance on a letter purportedly written on January 17, 2025 by the respondent number 1 to the petitioner, comma, a photocopy of which is handed over in court today, comma, indicating that the developer is ready to hand over the units to which the petitioners are entitled, subject to payment of the balance consideration in terms of the agreement, comma, along with interest for delay. Full stop, next para. It is further submitted by learned counsel that although in principle the primary dispute between the parties has been resolved, comma, it still remains to be ascertained as to the entitlement of the respondent number 1 herein to interest or otherwise. Full stop, next para. Learned counsel appearing for the petitioner seeks a week apostrophe time to take instructions whether the matter can be sent to mediation for the purpose of resolving the remaining disputes between the parties. Full stop, next para. For such purpose, comma, the matter is adjourned till November 7, 2025, when it will be listed under the heading to be mentioned for ascertaining whether the matter ought to be sent to mediation.
Would your
My lord,
lordship
can
also be
indeed-
pleased to record, my lord, that we've replied and disputed
Yes,
part of
that
the
is
letter?
exactly what I was also saying.
Lordship,
It may be it is also required to be mentioned here that a photocopy of a reply to the above mentioned letter on the part of the petitioner dated
That's-
February 6, 2025 has also been handed over today in court by learned counsel for the petitioner, which indicates that there remains certain issues to be creased, CREA-SED, creased out between the parties still, push up next para, in any event, comma, since in view of the above stand taken by the respondent one stroke developer, comma, there transpires prima facie to be a chance of the matter being resolved by mediation, comma, subject to agreement on the part of the petitioner. It will appear as to be mentioned next Friday. So that I can take it up in very first thing in the morning.
31st.
Lord,
Thirty-
Whatever it went down as 7th earlier.
Oh, not
Whatever
7th
is
then.
Milord convenient. to you,
October 31. October 31.
Lord.
যেটা 7th বলেছি 7th নভেম্বর বলছো ওটা, হ্যাঁ, আর October 31st. October 31.
Grateful.
Let it appear as to be mentioned. If we find that it is not possible at all to send for mediation, then we'll keep it again for you.
Deeply
Grateful.
obliged.
The copies of the letters handed over today be kept on record.
Grateful, my lord.
Any mentioning dispute ভদ্রতা
Mentioning, please.
নেই পুলিশ কোন
Item number 1.
It's from 330 or 2? Oh, these are old appeals. None appears for the parties at the time of call. Full stop. Considering the fact that the matter is pending for several decades, comma, another opportunity is being given to the appellant to argue the matter. Full stop. Accordingly, let the matter stand adjourned till October 31, 2025.
Item number 4.
Not ready for hearing. It appears from the office report dated September 24, 2025 that although the records, trial court records have arrived, comma, examined and found to be complete on May 21, 1973, comma, no paper books have yet been filed. Full stop. Be that as it may, comma, considering the long pendency of the matter, comma, the necessity for filing paper books is dispensed with, and the appeal shall be heard on the memorandum of appeal and the copies of the judgments of both the courts below, which are already on record. Full stop. As such, let the matter be listed for hearing under the same heading next on October 31, 2025. হিয়ারিং এর জন্য কিন্তু স্পেশাল এই হেডিং এই থাকবে স্পেশাল অ্যাসেন্ডেড তাই করে দিন তাহলে তাহলে আন্ডার দ্য সেম হেডিং আগেরটা ছেড়ে দাও ফর হিয়ারিং করে অ্যাপিয়ার ফর হিয়ারিং আন্ডার দ্য সেম হেডিং কথাটা বাদ যাবে
Item number 5.
Yes.
I'm appearing for the petitioner, Your Lordship.
Yes.
I'm praying for a day's accommodation.
Wait for a second, just let me see the office report first. You are for the appellant.
Appellant, Your Lordship. Apologies, Your Lordship.
No, the contempt application is yours.
Your Lordship.
One Mr. Indranil Roy Chaudhary has filed Vakalatna for the other side. Can you please give a notice to him that this is appearing?
Your Lordship. I'm
You can go through the records and find out what is his address or what.
grateful, Your Lordship.
An adjournment is sought on behalf of the petitioner in the contempt application. Full stop. Next para. Accordingly, let the matter stand adjourned till October 31, 2025. Full stop. The learned advocate appearing for the petitioner is requested to serve a notice of the pendency of the matter to the learned advocate on record who has entered appearance on behalf of the alleged contemners, comma, if any. I'm sorry, this Vakalatna was Indranil Roy Chaudhary is your person probably.
Your Lordship. Your Lord.
If any, full stop. If just ascertain if anybody is appearing for the other side, give a notice to him. If
Great.
not, then it will appear in due course and move it on next
Grateful,
Friday.
Your Lordship.
You give your appearance to me.
Item number 6.
Mr. Arifal is happening on the virtual mode.
5টা কি হলো 5?
Given
I-
this matter,
Yes, sir.
In this matter, I am
Yeah.
Lordship, on the last occasion, Lordship has directed us to serve on the contender number 1 again. But Lordship, that also has come back. They have provided us the address that has come back as refused.
Refused is good service. But Mr. Ali, then let us take up the recall application first because contempt.
The recall application is by a third party, Malay.
Not third party, Milord. I am the developer, Milord. Pursuant
So what
to
is your locus standi to file a recall application?
Yes, Milord. Because I have, because I was being
Let us
appointed as-
dispose of this recall application and then take up the contempt application. Mr.
Very
Ali.
well, Malay. Because the recall application does not concern me, I believe.
All right. What is the nature of the order under contempt?
The nature of the order is directing the walk-off board to take a decision on the complaints made by the petitioner.
Your complaints were against this developer who has now come up with the recall application.
There was none. The
specific?
developer wants the refund along with all interest and etc. That is not part of the order or anything.
Very well.
How would
একটা order record করে affidavit of service filed today be kept on record. First to be transpires that despite service, comma, none appears on behalf of the alleged container number 1. Full stop. Next para, at this juncture, comma, it is also evident that an application for recall of the order under contempt is pending. Full stop. Accordingly, the matter is taken up for hearing first. Yes.
Lord, I have solved the application for recall, my lord. Here is my affidavit of service. My lord, only one thing, I mean, led by Mr. Mukherjee, let it be taken
No,
up.
no,
for
recall application I'll dispose of, right? What is the recall for?
My lord,
You are a third party, you have no locus
my lord,
standing.
I was the defendant number 10 in the suit. I was
Suit?
in the suit. The suit was filed before the tribunal.
No, this writ this, oh, acha, acha.
This is a
This is a civil division.
Civil division application, my lord.
Yes, they're asking for time, Mr. Ali. Let us wait till next Friday.
Very well, but that does not there. Roshi will see that the recall application is also after 2-3 years.
Yes, we'll hear you on merits on that also as well as the material. Next para, at this juncture, comma, an adjournment is sought on behalf of the recall applicant. Full stop. The affidavit of service, you are filing your affidavit of service.
Yes, my
also.
lord, I have filed.
The affidavit of service filed shows that the recall application has also been served on the opposite parties. Full stop. On the prayer of the recall applicant, comma, let the matter stand adjourned till October 31, 2025, when the said application shall be taken up for hearing first, and immediately thereafter, the contempt application will be taken up for hearing.
Pursuant to the order of last occasion.
Yes,
by
yes.
your lordship, the board duly sent their name and address of the.
It has been complied.
Yes.
We'll take up that immediately after the Thank you.
Item number 7.
None appears for the petitioner at the time, none appears for the parties at the time of call. As a last chance to the petitioner to move the matter, the same is adjourned till October 31, 2025.
Item number 8 to 14.
It transpires that none appears to argue the appeal on September 18, 2025, when the matter was taken up and formal filing of paper books were dispensed with. Full stop, next para. As a last chance to the appellant in all the matters to argue the appeal, comma, the same is adjourned till October 31, 2025. এগুলো যেগুলো পেয়াবুক নেই দেবে পরের দিন না একটু যেগুলো লাস্ট চান্স দিচ্ছি একটু অর্ডারগুলো জাস্ট দেখিয়ে দেবেন আমি সবকটা ম্যাটারই
Item number 15.
আচ্ছা পেপারবুক আছে none appears for the part this is the second occasion when দেখি now this is the third occasion when none appears for the parties at the time of call. Full stop, next para, as a last chance to the appellants to argue the appeal, comma, the same is adjourned till October 31, 2025.
Item number 16.
Same order. Action দুটো occasion appear করে হ্যাঁ সেম অর্ডার আগেরটা এক্স্যাক্টলি আগেরটা যা তাই ঠিক আগেরটা
Item number 17.
সেম অর্ডার
Item number 18.
সেম অর্ডার পরের ফ্রাইডে সোমবার থেকে লিস্টে করে দেবেন পরের ফ্রাইডে ইয়ে অরিজিনাল সাইড ম্যাটার চলবে 3টে পর্যন্ত হ্যাঁ
ওদের একটু বলে দেবেন অরিজিনাল সাইড লিখে দেবেন 3টে পর্যন্ত আর অ্যাপিলেট সাইডের লিস্টে যেটা 2 PM এর বদলে 3 PM হবে। হ্যাঁ হ্যাঁ শুধু 2 এর জায়গায় 3 হয়ে যাবে যা আছে অ্যাপিলেট সাইড ম্যাটার্স উইল বিগিন 3 PM or after completion of origin whichever is earlier 2 এর বদলে এটা 3 PM হয়ে যাবে সোমবারই দিয়ে দেবেন মানে ফর ফ্রাইডে এই ফ্রাইডে থেকে আর থাকবেন